May I please, Lord? I'd like to mention one review application, maybe on 20th or 21st of this. May it please, your Lordship. My Lord, attempt number 3, your Lordship, directly to produce the record. I have not yet received. My Lord, meta may come on Monday, my Lord, with the record. My Lord.
If I may please, your Lordship, I beg to mention item number 70 on the
adjournment GGS है लिखे थे adjournment
give a adjournment your name whom you represent
ये लिखे admission for admission item 1
May it please, your Lordship. My Lord, Mr. D. Sahu is out of retention.
Yes,
Mr. D. Sahu is out of station for personal difficulties, my Lord.
a little louder.
Well, Mr. D. Sahu is out of station for some personal difficulties, my Lord. Lordship may allow can be taken up on next Wednesday if the Lordship allows.
Adjourn on the inconvenience of Mr. D. Sahu, learned counsel for the petitioner.
item 2
Some seizure valuation was made at the time of seizure.
Yes, sir.
They say now that the value of the goods is much more. Did you at any stage challenge the valuation?
No, we are seeking that valuation only. The valuation,
Sorry,
we are seeking that valuation only. The valuation that was made at that time, we are requiring that valuation only.
then why this petition then?
In the meantime,
Then you withdraw it.
my Lord, during pendency of the appeal, my Lord, the goods were sold, my Lord, in auction.
Ah.
In auction, the amount came to rupees 1,50,000, my Lord. And our value of goods is 5,88,000, my Lord.
So you challenged the auction.
Subsequently,
How do you expect the state to pay you more than what they got by selling your goods?
subsequently, what happened, my Lord, the order of confiscation was set aside, my Lord.
I understand,
My Lord.
but it must have been some kind of a perishable goods,
Yes, my Lord.
or under the law, they could have auctioned it.
Yes.
They have done it. How do you expect to get more money than what the state had got? Unless you challenge the auction. When the auction was going on, you ought to have challenged it then and there that I raise an objection on this auction because you are undervaluing the goods and selling it.
And in spite of receipt of notice, they didn't participate in the auction.
You always have the option. When you participate in an auction, you know what is going on. If you feel the value of a good is 5 lakhs and they're selling it for 1 lakh, raise the objection. Don't allow that auction to go ahead. But after years after, you say, no, give me back my value. Under which law? Is there any law?
I got one judgment of the apex court, my Lord.
What does it say?
Wherein, my Lord, apex was a little bit similar, my Lord. What happened there also, my Lord, appeal was pending before the honorable apex court.
What did the apex court say?
My Lord, apex court, my Lord, just I'm reading out, my Lord, operating court. What is overlooked by the learned counsel is the consequence of setting.
Learned counsel.
No, the observation, my Lord, just
What is overlooked by the learned counsel?
Learned counsel is the consequence of setting aside the order of confiscation on the ground of it was illegal. The applicant has become entitled to the value of the goods as on the date or time when the goods ought to have been cleared by the respondent from consumption.
So now what is the value of the good? Value of the good is auction.
My Lord.
Auction is one of the best means to evaluate a goods because a purchaser knows what is the value of the good and he will be ready to pay to the extent he understands to be the value. So now, if you say, no, my value of my goods is much more,
what
kind of relief you expect?
Auction was done much later, my Lord. Basically, the life of the goods were of 6 months, 8 months. The goods were seized in 2012, my Lord. Auction was done in 2000.
So then I think you'll have to go for civil suit.
In this case, also the court has
Understand? Then you have to go for civil suit that negligently you allowed the goods to be devalued.
And during the pendency, my Lord, we have made several applications under section 110.
What is 110?
The provisional release law.
That prayer was made, my Lord.
Sorry, 110 of what? Customs Act?
Customer, I'm giving my Lord.
Lord, interestingly,
Customs Act on sound?
that was certified by the experts, Lordship, the value of the goods at the time of auction.
In any variety matter, you ought to have challenged it then and there. Your legal right was violated when they have undervalued and put it up in auction. Your legal right is not violated when you file this writ petition.
And
We have taken this ground in our affidavit that they have not, in spite of notice, they didn't participate in the auction.
You cannot do that.
Section 110 capital A.
Lordship, otherwise Lordship may take on when I will satisfy Lordship on this point.
What is section 10 of the Customs Act?
110 capital A.
No, he is referring to
110 capital M.
110 capital A. Let us read what it is. So you have made an application under 1110A.
My lord.
What order was passed?
No order was passed, my lord.
What prevented you from coming to the court seeking a direction that you pass an order in my application?
Yes, so, my lord. We prepared an
So
appeal, my lord.
after all these lashes on the part, how can you say now give me back my money? Hmm.
Lordship may take on Wednesday, I will satisfy. Mr. Sahu is not able, I will do it, I will satisfy him.
Okay.
Blind.
Item 2.
Yeah, they did like that.
In that case,
That,
they have
matter.
tick mark.
Double tick.
By the last order
Hmm.
of 13th of October 2023, your lordship made an observation in the
Hmm.
last paragraph that in the
Hmm.
circumstances, respondents.
To explain how the grievance of the petitioner can be mitigated.
Yes, no, I just say that lordship may kindly observe that we file an affidavit because verbally taking instruction 2-3%.
By the order of 13/10/2023, the respondents in the Food, Civil Supplies and Consumer Affairs Assam was required to explain as to how the grievance of the petitioner can be mitigated to the extent that two tick marks were noticed in the answer scripts
As per
of the petitioner
as per the report, ma'am.
as per the report, comma, without any further material that it is the petitioner himself who had done it. The manner in which the grievance of the petitioner is sought to be mitigated may be put forth in the form of an affidavit by the respondents. List. Did you?
Item 3. Short bill. To be, let it on 7th of Thursday. So by the time we file the affidavit.
He has the instruction, but he wants to get it in writing.
Let it be, let it be
Always
1 week. So we did 1 week.
No, no,
1st December.
Let, all. 1st December, all right.
Item 3.
Unless there is an
Much
agreement, it's
of-
very difficult to.
Okay, can you have it on 17th December?
17.
No,
My lord.
Item 3.
Yes,
The last order you
Mm. Why the records are not available?
Actually, they have sent part of the record, but only the.
And who had advised them to send part of the record and not the whole of the
Actually, my
record?
lord, the proceeding books are not, my lord, sent, they are sending, my lord, today, my lord.
No, we don't appreciate this kind of a approach. Ask him to come by 2 o'clock. Where is this place?
No, it's
Lakhimpur.
Lakhimpur, not Lakhimpur.
Tomorrow.
Tomorrow,
Ask the peon to come with the records. List tomorrow for the complete records.
4, 5, and 6.
Where is Mr. RM Das gone? I think. Yes, Mr. You are Borua or Bora?
Bora.
Bora. You argue, what is your case? You are the writ petitioner. What is your matter? You argue it out, please.
My case is very simple. They belong to XT garden category.
Sorry.
Right? My case is very simple. They
No, we don't want simple case. We don't want complicated case. We want to know what is your case.
they belong to XTZL category, not
They belong.
Yeah.
Why do you say they belong to XTGL? Why do you say that they belong to XTGL category?
Because their certificate says so.
Certificate. What is a certificate?
So, document.
What is a certificate?
Document based on a fact.
Document based on a fact. Okay. Is it a fact that you are a XTGL? Certificate you say is based on fact. Is it a fact that you are a TGL?
Petitioner says so.
Petitioner says so. So it is a self-declaration. Is self-declaration determination of a fact? Suppose Mr. Chaudhary now he says that I'm a multi-billionaire. Will he become a multi-billionaire? He'll say it. Or Madam Chaudhary may say, I am so and so. He may say, I'm a judge of the Supreme Court, then make a statement. What do we do? If fact is to be determined only on statement of a person or claim of a person, then Mr. Das can also claim anything, say anything, yes. Come to terms. So now, what do you want? So you claim that you are TGL based on a certificate. Certificate, we don't know under what circumstances it was issued. Go to the committee, get it verified. Okay. And আগৰ অৰ্ডাৰটো আছে নেকি অলপ যে মাৰি থৈছিলো কাবাৰ তাত আছে কোনে মাৰিছিলে সেইদিনাখন Yes, you have to submit anything.
I'm supposed to that you like want to propose it off if you also want to want them to appear before the committee and we are okay with that. Subject to the condition that they actually go and
Somebody was saying that some division bench order. Is it?
Yes, of course.
Is it in conflict in any manner?
Yes, in fact, my learned friend has just pointed it out that in Madhuri Patil itself, there was an observation made by the apex court that against a single bench order, no further appeal would lie before a division bench. If any appeal would lie, it would lie before the honorable apex court under Article 136. That is what my learned
So this division bench order will have to ignore then.
Perhaps,
Which paragraph? Which paragraph?
Page 256.
In fact, Mr. Das, this was my very thought in my mind why the earlier order was passed. Depriving a genuine candidate. That is more of a concern for a court than whether somebody claiming is it a necessary that all certificates are required to be scrutinized? No, Mr. Bojumdar is saying vehemently no. Why are you saying no, Mr. Bojumdar?
Talking about that, my learned friend, what.
No,
he
no.
said.
If you read para 13 of Madhuri Patil,
Yes.
Yes, Lordship.
on that basis we are asking.
Kindly come to sub-para 10 of para 13.
No, don't come to
The-
sub-para 10. Come to the main paragraph.
Yes, Your Honor. And the guidelines which have been laid.
Understand? We'll go to guidance later. Read the purpose. The admission wrongly gained or appointment wrongly obtained on the basis necessarily has the effect of depriving the genuine scheduled caste or OBC candidates enjoined in the and benefits confined. The genuine candidates are also denied admission to institutions or appointments to post under a state for want of social status certificate. The ineligible or spurious person who falsely gained entry and create hurdles in completion of the inquiries by the scrutiny committee. It is true that applications for admission are generally made by parents. Since on that day, it is the parent or the guardian who may play fraud claiming false certificate. It is therefore necessary that the certificates are issued. It is in general. It is not said that only when there is an allegation.
Certificate issued are.
That is certificates issued are scrutinized at the earliest. So is it a mandatory requirement to scrutinize each and every certificate? And this one you see that guideline 3, application for verification of caste certificate by the shall be filed at least 6 months in advance before seeking admission to an educational institution. So is the verification a mandatory verification of every certificate? Mr. Mojumdar, if you want to say something, please come forward, formally enter the proceedings. We are not interested in any comments from the audience. If you want to say something, if you have something valid to say, come forward, formally enter your appearance and tell the court. What do you want to say?
After the judgment.
Whom are you representing? None. So you want to share your knowledge? Yes, you can do so. What do you want to say? What do you want to say?
The judgment as I have read it.
Sorry?
Said, the judgment as I have read it said that when applications were being filed, then they will go to the entire.
No, we are asking the meaning of paragraph 13. That's all.
Certificates which already existed. Once the question arises, a complaint has to.
No, where is the provision that it will go to the committee only when question arises? Does any of the preceding paragraphs indicate it so? Especially meaning of this line. It is therefore necessary. Why it is necessary? Because there is a possibility of spurious candidates being also there. Are scrutinized necessary that are scrutinized at the earliest with utmost expedition and promptitude. For that purpose, it is necessary to streamline the procedure. And what is the procedure 3? Application for verification of bidders shall be filed 6 months before seeking admission. So anybody who relies on a caste certificate seeking admission, if we read 3, then he has to make an application 6 months prior. Whether somebody questions or somebody does not question doesn't matter.
Paragraph 13.
Ultimately, Supreme Court does not have any faith on the issuing authorities. It is only the committee.
Paragraph 13, third last time, my lord, where lordship.
Sorry.
The paragraph 13, my lord. For this purpose, it is necessary to streamline the procedure for issuance of social status certificate. So when the issuance comes, then
that's why procedure for issuance of social caste. So if this procedure was not followed, that certificate has to be rejected outright.
Whatever was there existing prior to the law, for them on a complaint it happens, and for
so this is a judgment of 1994.
Any certificate.
And these are, we are in 2023, after 30 years down the line.
If they applied after that,
Hmm.
then this procedure has to be.
I think Mr. Mojumdar, he may be right in saying so. For that purpose, necessary to streamline the issuance of certificate, application shall be made to the so-and-so parents, application for verification. So this is what I am saying. Moment the certificate is issued, there is also a corresponding subsequent requirement to get it verified. Unless the verification seal is there, this may not be a valid certificate.
In fact, in the state of Arunachal, Madam, only last year they have constituted that committee. That committee did not exist till last year.
We are in Assam, not in Arunachal. Let Arunachal matter come before us, we'll deal it separately.
Sometime in 2015. In 15.
All
first
the state
committee-
governments shall constitute a retriever or so and so, so and so, and so. Each directorate should constitute a vigilance cell consisting of senior so and so. Read that clause 5. Clause 5, Mr. Das, it appears that vigilance cell will be there in each directorate. Vigilance cell did not be a part of the scrutiny committee.
Yeah.
In our case, I think it's been made a part of the scrutiny committee. It has to be
In the correct.
in each and every directorate, means every office, every department, every directorate, they will have the vigilance cell consisting of a senior deputy superintendent of police in overall charge and such number of police inspector to investigate. And what will he investigate? All these things then come to placitum C. He should also examine the parent, guardian, or the candidate in relation to their caste, etc., or such other person who have knowledge of the social status, and then submit a report to the directorate, along with all particulars as envisaged in the pro forma, in particular of the scheduled tribe, relating to their peculiar anthropological, ethnological traits, deity, rituals, customs, mode of marriage, death certificate, method of burial by the caste or tribes or concerned. Only after these verifications are made. Sometime back, we had one case of, I think Mr. Soroni argued that matter. Somebody says that I belong to Boro Kosari community. Brings one certificate from here and there. And certificates in our country, there is no dearth of certificates. Go to anybody, they'll give you a certificate and send you back. And the man feels very important. Yes, I'm a man to certify, take the certificate, go. Thank you for the honor bestowed upon me. This is where we are. So therefore, these are the things to be gone into by the Deputy Superintendent of Police. And once you do this, suppose in that case, the Bodo community, Kosari community has a particular manner of doing all these things, like ethnological deity, ritual, custom, mode of marriage, death certificate, method of burial, etc. If then find out from this family whether they do it or not. If they do it, possibly they belong to that community. If they don't do it, possibly you don't. This appears to be a very, very detailed scrutiny. It's not just something discretion of one man here and there. If you go to our government offices, at present, I don't know, I am talking about the earlier years, the clerk will say, Sinta no koribo, main column likhi dim. We are in the culture of a column likhi dim. I will write one line, your matter will be taken care of, you don't worry. Director concerned on receipt of the report, if he found a claim also to be not genuine or doubtful or spurious, director concerned should issue show cause notice supplying a copy of the report by a registered post with acknowledged due through the head of the institution in which a candidate is studying or employed. This can be done even subsequently.
Yes.
The notice should indicate the representation or reply, if any, and would be made within 2 weeks. In case the candidate seeks an opportunity of hearing and claims inquiry to be made on receipt of the report, shall convene the committee and join. Give reasonable. So this director, I think, has to be understood to be the committee itself, or what?
Paragraph 14, clause 4. That's the director.
Should constitute a committee of an additional secretary, so the director, social welfare, and who has knowledge. No, this is committee. Then 5 is each directorate. 6 is the director, not the committee. The on receipt of shall convene, shall give reasonable opportunity to the candidate to adduce all evidence support. Public notice by beat of drum or any other convenient mode may be published in the village, and if any person opposes such claim, an opportunity to adduce after giving a. So here is that division bench thing, na? 2 months and 1 month, 3 months. This expressly appears to be an outer line. Not the inner line, that minimum 3 months should be given. It's a maximum. And what is to be given is scrutinized at the earliest. And again, 10 is also circumscribed by day-to-day proceeding. So what we do is to paragraph 5, subparagraph 5, as this is in respect of a general scheduled caste or scheduled tribe or OBC candidate. Here we are dealing with a specialized category of OBC, that is the XT garden. We add one line that a verification as to the which predecessor in interest was a tea garden laborer should also be inquired and verified. Because only belonging to the anthropological and ethnological trait will come to a conclusion that whether the person belongs to any of those 96 communities enlisted in entry 24. But the main requirement, whether you belong to tea garden or not, will not be included. So we add one line here.
Regarding the issuance of certificate by the in tea garden community, the Khas Janagosti Unnayan Committee used to recommend After that only government is to
So therefore, there is a requirement of a verification
lordship, that is.
because Supreme Court has recognized it. Genuine the ineligible spurious person who falsely gained. Supreme Court has judicially accepted the existence of spurious claims. Then it is for the parent and guardian who may play fraud claiming false certificate. So to overcome this, there is a necessity to that these certificates issued in past tense, means what has already been issued as per the recommendation of Janajati or community or whatever it is, are scrutinized at the earliest. And for this purpose, what is to be done? Clause 3, application for verification by the committee shall be filed at least 6 months. So every certificate, unless it is preceded by an application submitted prior to 6 months and verified by the scrutiny, may not be acceptable in law in view of this judgment. A mere certificate may not be acceptable.
Yes, for your lordships, the Sarjanjali themselves have said that these certificates which they are saying are correct, and they have declared them to be invalid. I have annexed one such document in.
I understand.
petition.
No, this is what we are saying. In our country, there is a culture of issuing certificates. And if anybody approaches any person that please give me a certificate, he feels very important of himself. And now I'll give you a certificate. And he issues it. Least realizing whether he is competent, whether he should issue, whether he should not issue, implication thereof. No one is concerned. His self-importance is more important, that I'll issue a certificate now. Otherwise, we would not have been in this kind of a situation.
Particularly in this particular district, you note that all the 3 cases relate to Karbi and law. And we are facing a lot of difficulties in admission to current.
Understand.
This particular.
Your school is from Karbi Angla, your school.
All three petitions.
And where is that provision? No division bench?
That is a little.
10 and 11. Page 256, subclause 13. And 11 and 13.
Yeah, inquiry should be completed, expedited.
No, 13, lordship. The High Court would dispose of these cases as
The High Court would dispose of the as early as possible within 3 months. In case as per procedure, writ petition is disposed by single and no further appeal.
My clause 11 has to be read first.
Order of the committee shall be final and conclusive only on the subject to the proceeding.
Thereafter, no suit or other proceedings for any other authority should lie. And the High Court would dispose of.
So like we are doing it, we have to do it within 3 months.
Yes.
And
And
the committee will give it as expeditiously as possible, day-to-day hearing. Outer limit is 2 months plus 1 month. And not beyond that. And once the single judge passes an order, no appeal.
once the verification comes from the committee, then only 226 and then directly to 1.
Yeah.
No difference. But in our case, that verification is not get in this particular.
So let the verification be done. We put in everything. All these para 13. In case certificate obtained is found to be false, parent guardian, the candidate should be prosecuted for making false claim. If the prosecution ends in a conviction, it's a very elaborate order actually. Everything was taken note of. If the prosecution in a conviction ended, it could be regarded as an offense involving moral turpitude, disqualification for elective post officers under the state. even that question has been taken care of. That once you are admitted, later on you come and claim equity, that I am already in this, that is also taken care of. That is also taken care of.
One is being.
A party seeking equity must come in clean hands, and there is no place for any fraud. Such when such again, that case, the candidate completed the course.
One of the sisters gets it.
No, it's course completed, only examination is to be there. There also Supreme Court says, we direct the principal to permit her seat for fine if she has completed the course as represented to us, but not with the social status as a scheduled tribe. If you have got admitted as a scheduled tribe, you cannot even sit in the exam also. But otherwise, they say that otherwise we are also entitled. If it is, you allow her to sit. And that too not as a precedent in use. Next sister was not allowed. One was allowed. And mind you, here again, the fraud is not, you do not belong to the caste. Fraud is para 19. She appears to have wrongly gone to an officer who had no jurisdiction. It's only a jurisdictional error, not even a false claim. In the case before the Supreme Court, X ought to have issued the certificate, somebody went to Y. And where Y did not have the jurisdiction. And it is not a case before the Supreme Court that this person does not belong to that community. Not belonging is even a more serious fraud.
But regarding her elder sister, who has been allowed to continue her study since she was in final.
There also
one bar is there. That her further studies in.
further nothing way. As you have completed everything, 5 years gone, only exam. You sit that too again, subject to if she had completed the course as represented to us, but not with the social status. Who appeared? R. Borua. You are R. Borua. You are Boran. You did not appear before the division bench.
Those are medical.
Somebody. হেৰি ৰেকৰ্ডটো চাওঁ WBC 5340 কল কৰিব নেকি চাওঁ পাতি দিয়কচোন কি আছিল This is nothing, doesn't provide for anything. Other than using some expressions here and there, legally speaking, it possibly doesn't provide for anything. Other than get it re-verified once again. And re-verified in accordance with the guidelines. Guidelines we have read, para 13. 13 is the guidelines, follow it. And only one expression yes. Anything more?
An undertaking has been taken in terms of this.
So ultimately, this consequence will be,
They are all studying the.
they'll be subjected to the consequence of
In case they're.
found false. They will be, parents will be prosecuted, number one. And secondly, the proceeding should be day to day as far as possible. Go by the Supreme Court. Only thing, it should not exceed 2 months. Not that it's a minimum of 2 months has to be given to anybody. Then This one. The principal, etc., responsible making admission or appointing authority should cancel the admission without further notice. Clause 15. You follow that? Follow the procedure and do the needful. Now question is, we keep this petition pending or we dispose it off? We don't leave everything to us. We go by the law.
But perhaps keep it pending because then clarity will come from all sides and there will not be any confusion. The authorities are sometimes in the position where if we immediately cancel the admission, some claim might be made against us saying that we have cancelled without the legal report. Perhaps let the committee report be placed for a lot of close the if and that entitlement to challenge the committee's findings will always be there in terms
You can committee, you can always challenge. Then that the Supreme Court is provided.
clause 11.
I think 11 shall be final, conclusive, subject, no suit. High Court to dispose cases within a period of 3 months. No further appeal. And it will be in the lines of a judicial review. I think one line is there somewhere.
Judicial review is not there.
Paragraph 15.
Unless para 15, judicial review of any high court. But that will be a separate proceeding, I think.
That will have to come back challenging the findings of the committee if it is an adverse finding against them.
You file a separate writ
Then let them
against
file
them.
Otherwise, also, Lordship, keeping it pending will not serve any purpose because ultimately the committee will decide what is the cost of this petition. Then they will inform the principal of the respective court.
No, Supreme Court has the direction. As soon as the finding is recorded, it should be communicated to Education Institute and the principal will cancel the admission.
Once the committee decides,
Supreme Court has already provided for it.
dispose of it. So Lordship may dispose it of.
Indication as per paragraph, clause 15.
Only remedy remains will be regular para 15. Whether the approach adopted by the
The only
and ought to prevail unless found vitiated by judicial review of any high court. Heard Mr. Arbora, then counsel for the petitioner. You were also there? Are you also there?
in one of the items.
Item number 5.
So we are passing a common order.
Yes.
It already appeared before the committee.
Then we pass in only one case. His case, we put it separately. As he has already appeared, they'll follow the procedure.
Yes.
Two cases.
Uh,
5, 4 and
4 and 6.
Four and
My lord, very 4 and
4 and
6. Which is WP
39.
3975. 3975.
Yes, and 7-6 also.
3975, 977.
7-6.
Oh, boro. Hitu দিব next to.
But the only apprehension with the state is that sometimes in the future, or may perhaps recall, in 2020, similar batch of petitions were filed before this honorable court. And therein also a direction was issued by a lordship saying that the scrutiny committee should sit and decide on these applications. But if 3 years hence, the students still continue to study with us without any finding of fact on their status by any company. And
Those
unfortunately.
petitions are pending.
No, the petition were disposed of. Saying that those, the children should be allowed to continue for the time being till the finding of the scrutiny committee. The scrutiny committee does that in those cases only in the year 2022, August 2022.
No, you'll put a specific direction. It should be expeditiously day-to-day proceeding, outer limit of 2 months. And further 1 month is to give a notice to the others. Committee has only 2 months.
This judgment should be a precedent. This judgment should be a precedent. The judgment,
Sorry.
then the judgment which my lordship will pass, it should be a precedent. Means for future cases. Otherwise, it will come like this only. The scrutiny regarding the verification of by the scrutiny committee, as stated in this case.
In which case the deputy commissioners appeared in this case or?
No, the other one, the medical admin.
I think here also they appeared. Personally appeared
Appeared.
and had made a categorical statement that there is no verification.
Yes, yes. In these cases also they appeared. Deputy
Can you
Commissioner West Corby-
have the name of the deputy commissioner?
Deputy Commissioner West Corby appeared personally.
Get the name, we'll record that statement that
Find it on, in the order dated 11/9/2023 of the lordship.
11/9/2023.
So, I apologize, 12/9/2023.
12.
8WC 2705. I'm just giving you. Of the order.
সেইখন দিলে হ'ব।
2705.
No, no, it's there. 12/9.
12/9.
Madhumita Bhagavati, Deputy Commissioner, so and so are present. Personal appearance, however, হেৰি লিখিব Union of India, who appears? You appear? MS Steve Fukan, Land Council for the respondents in the Ministry of Human Resource Development, Government of India, comma, MS R.S. Chaudhary, Land Council for respondents in the Navodaya Vidyalaya Committee. So being the authorities under that, I think whosoever it is, it's covered instead of going one by one. Mr. P. Saikia, learned junior advocate for the Deputy Commissioner West Karbi Anglong. Mr. R.M. Das, learned counsel for the welfare of plain type will appear. For the respondents in the Social Justice and Empowerment Department of the Government of Assam, who had entered appearance as respondent number 6, although the respondent number 6 is depicted to be the Commissioner Secretary to the Government of Assam in the welfare of plain tribes and backward classes development. It is clarified that the welfare of plain tribes and backward classes department had been bifurcated, and the Department of Social Justice and Empowerment is one of the departments as a result of the bifurcation, and the subject matter involved in the present writ petition regarding the caste certificates of the candidates claiming to be belonging to the tea garden labor ex-tea garden labor communities are within the purview of the Department of Social Justice and Empowerment. Twelve petitioners have jointly filed this writ petition. Claiming that they belong to the Nunia community, and Koiri community, and as the two communities are recognized to be other backward, Mr. Mishra, this judgment I'll take some time. That's why I'm pointing out, as per your convenience. It should take about maybe an hour or so.
Because other matters are also there.
Okay,
Mine is in hearing second.
at 2 o'clock.
I'll come.
8 rupees of loilo. People, community. All the petitioners, upon passing their class 5 annual examination from their respective schools, applied through the online mode for selection, for selection for admission to class 6 in the Jawahar Navodaya Vidyalaya. Selection. And accordingly participated in the Jawahar Navodaya Vidyalaya selection test. Upon such application, admit cards were issued to them. Participated in the selection test, and as per the provisional select list dated 19/6/2023, they were shown to have been selected for the admission. Right? In order to carry forward the admission process, there is a requirement from the respondent Jawahar Navodaya school authorities to produce the relevant certificates from the competent authorities in respect, amongst others, of the reserved category candidates, of the reserved candidate, comma, amongst others, of the other backward classes, bracket OBC candidates. The petitioners accordingly produced the OBC certificate, their respective OBC certificates, which are annexed as Annexure C series to the writ petition, and were issued under the signature of the President / General Secretary of the All Assam Other Backward Classes Association, and it also contained the counter signature of the Deputy Commissioner of the West Karbi Anglong, the Deputy Commissioner Karbi Anglong, or the Deputy Commissioner Karbi Anglong District. Where is the certificate of Konoklota? In which page?
What is the caste certificate of the father of the her father has been elected. Her caste certificate that she applied, that is not been issued by the deputy commissioner.
কি করলো? Respective ODF issued their OBC certificate issued to their respective father / parent / guardian by the omuk. Huh? Then what happened? They wanted certificate in the name of the candidate. But the respondents in the Jawahar Navodaya school authorities did not accept the OBC certificates issued to the respective parents / guardians of the petitioners. And am I correct?
In fact, because in the guidelines which were issued for the.
That you need a certificate of the candidate.
Clause 3.6.
By referring to clause 3.6 of the 3.6 of the school prospectus. Now, what did you do? You applied for the certificate.
Yes, the petitioners, they applied for the certificate.
Accordingly, the petitioners applied for their respective certificates.
Before the deputy.
But not issued. But such certificates were not issued. In the aforesaid circumstance, the writ petition WPC 3975/2023 has been instituted. Seeking for a direction to the respondent number 4, being the authorities of the Jawahar Navodaya Vidyalaya school, to allow the petitioners to be admitted in class 6, with a further prayer for a direction to the Deputy Commissioner Karbi Anglong, Hamren, to do the needful for issuing the OBC certificates in favor of the petitioners. Any affidavit filed? The respondents in the Jawahar Navodaya Vidyalaya authorities have filed an affidavit in opposition, wherein wherein a stand had been taken that '69,
Starting from page 69, the actual stand page 73,
'73.
the last paragraph, that clause 3.6.
That we have already recorded. Taking a stand that the petitioners, by claiming to be belonging to the Nunia and Koiri communities, are otherwise do not belong to the other OBC category unless their claims fall under entry 24 of the notification dated. Itu eta notification date eta ase. Mr. Das, that notification, entry 24, 99, 98. Of entry 24 of the list of OBC communities in the state of Assam, as per the notification, as per the Gazette notification dated 13/9/1993.
Ten nine. 10/9.
Mr. Bora, it is most irrelevant whether it is 13/9 or 10/9. You can correct it at the end of the order without disturbing us in the middle. And for your information, page 19 is 13/9. Please, Mr. Bora, please relax. Hello.
By claiming to belong to the India and Korean communities or otherwise belong to the OBC category unless their claims fall under entry 24 of the list of OBC communities in the state of Assam as per the notification.
Entry 24 of the Gazette notification dated 13/9/1993. Gazette notification number eta ase, Hindi to ase, English to para jodi di diba. Kabata complete khon ase. Is extracted as below. In the said Gazette notification, under the column name of caste communities, including subcaste stroke synonyms in the common list, entry 24, as noticed, is tea garden laborer, tea golden tribes, ex tea garden laborers, and ex tea golden garden over tea garden tribes, and ex tea garden tribes as enlisted, comprising of 96 different communities. A reading of entry 24 of the notification dated makes it explicit and discernible that the 96 communities enlisted under entry 24 are not the recognized and accepted OBC communities in the state of Assam. On the other hand, it is the tea garden laborer, comma, tea garden tribes, ex-tea garden laborer and ex-tea garden tribes who are the enlisted and recognized OBC in the state of Assam, subject to the condition subsequent that they also belong to either of the 96 communities and as enlisted in entry 24. In the instant case, the petitioners claim to be belonging to the OBC category by referring to the certificates issued to their respective parents and guardians, fathers, parents and guardians, that they belong to either Nunia community or Koiri community. But such certificates ipso facto do not certify that the father, parent, guardian of the petitioners do belong to the ex-tea garden laborer, comma, tea garden tribes, comma, ex-tea garden laborer and ex-tea garden tribes. It only certifies that they may belong to the Nunia community or the Koiri community. As this writ petition is instituted with a prayer seeking a direction to the Deputy Commissioner Karui Anglong for issuing a certificate that the petitioners belong to the OBC category under entry 24 of the notification dated 13 1993, comma, and also taking note of the stand in the affidavit in opposition of the respondent in the Jawahar Navodaya Vidyalaya authorities.
Normally called as Navodaya Vidyalaya Samiti.
Navodaya Vidyalaya Samiti. A horror correction will correct you. It'll be done. Comma, Kikolo.
Belong to the OBC category under entry 24 of the notification dated 39 and also taking note of the stand that
By our earlier order dated 11/9/2023, we had taken note of the statement of MS Binita Pegu, the Secretary to the Government of Assam in the Social Justice and Empowerment Department. As regards the interpretation of the provisions of clause 24 of the notification dated 13/9/1993. As stated by the Secretary to the Government of Assam before the court, comma, as well as upon examining the respective certificates issued to the father, parents, guardians of the petitioner. People, petitioner. It prima facie appeared that the determination made by the authorities issuing the certificates was only in respect as to whether the person seeking the issuance of the certificate belonged to any of the 96 enlisted communities under entry 24 of the notification dated so and so, without complying with the pre-required determination as to whether the person seeking for the certificate do belong to the tea garden laborer, his harita je ase omuk omuk community. In the circumstance, we also required the Deputy Commissioner West Karbi Anglong District to remain present before the court to explain as to the procedure that had been adopted for issuing such certificates. On 12/9/2023, Srimati MSA Madhumita Bhagavati, Deputy Commissioner Karbi Anglong, stated before the court that the OBC certificates issued are countersigned by the Deputy Commissioner without any further verification as regards the authenticity of the claim of the respective claimants that they belong to the Tea Garden Omogomo community, and further that they also belong to any of the 96 enlisted communities under entry 24. The Deputy Commissioner also candidly made a statement before the court that no such verification process is adopted as to whether the applicants do actually belong to the Tea Omogomo community. Record to pala ni. Aku kalau kita naik. Itu je question. Oleh 1999 nice one. Good good. 1999 2299. Episode bari hai वैसे. Now we're inside the program.
19-9.
19-9 or 29.
40
Immediate নাথাকে নাকি রেকর্ডার এগুলো লাগে তো sound print out পাই নাকি 99 or 29 to sound no there we analyzed who is a tea garden some a report from the LRI was also obtained if I remember correctly LRI report এটা আছে এইটাকে নোয়া কেন কেবল যদি ছিল খুঁজিব ইনকোয়ারি করবেন why the order has been taken out no not this order
print
oh no একটু বেলেগ so this is 1910 of the division bench 1909 in
That is the wrong one in that. I'm sorry, I'm holding my hand for this.
I think some analysis was made who is a tea garden. For that purpose, I need it. Now, in order to understand the interpretation of entry 24 of the notification dated so and so, we also heard the learned DSGY for the Union of India who had issued the said notification. And it is the categorical submission of Mr. R.K.D. Chaudhary, learned DSGI. Can you have Mr. Chaudhary, R.K.D. Chaudhary? Because that if a person merely establishes that he belongs to any of the 96 enlisted communities without establishing that he also belongs to the category of tea garden laborer, tea garden tribes, ex-tea garden laborer, stroke ex-tea garden tribes, such person would not be accepted to be an OBC in the state of Assam under entry 24 of the notification dated 13/9/1993. to understand as to which category of person would be categorized to be belonging to the tea garden laborer, tea garden tribes, ex-tea garden laborers to ex-tea garden tribes in the state of Assam. We have perused certain materials available by the Law Research Institute of the Guwahati High Court, which provides for the origin of the tea garden laborer, tea garden tribes, ex-tea garden, that it goes back to the British colonial era when certain people belonging to the Adivasi communities in the states of Odisha, Jharkhand, West Bengal, Andhra Pradesh, and Chhattisgarh were brought to the state of Assam for the purpose of doing manual work as laborers in the tea gardens of Assam. An extract from a research paper made available by the Law Research Institute is as below. Etu quote kori thoi dibo na. More than a head etu. Here going to be. Right. Call me uncle. Equal. It extracted. The origin of the tea garden Omogomu tribe makes it explicit to the extent that in order to belong to the category of tea garden Omogomu tribe, a predecessor in interest of the claimant or the predecessor in interest of the claimant would necessarily have to be a laborer in any of the tea gardens in the state of Assam. In other words, in order to be included in entry 24 of the notification dated 13/9/1993, Mr. Chaudhary, one of your submission in another matter I have quoted in this order, so therefore I required you, whether you agree with it or not, that to be belonging to that 24 entry, ex-tea garden labor, first you have to be tea garden labor, then 96, because I have quoted that, as you said. It's okay. So I should do it in your presence. That's why this also same issue is involved. So we can record that statement, submission.
That was my stand in that case.
Yes.
I stand by it.
In order to be included in entry number 24.
There is a prerequisite that the claimant must satisfy, that either the claimant himself or herself or any of their predecessor is or was a tea garden laborer in any of the tea gardens in Assam.
Last the one paragraph person.
In other words, in order to be included in this entry, there's a prerequisite that the claimant must satisfy with either the claimant itself or itself or any of their predecessor
Was a laborer in any of the tea gardens in Assam. Finance or Negi, boy, yes. I can notice you. কৰে অলপ বহক এইটো টাইম ল'ব অলপ যিটো কৰি আছো Bora, you take your seat. Or you want to say something?
No.
It's okay. You are required to stand only when addressing the court, not when you are listening to the court. Reservation is a constitutional concept. To favor certain backward communities. So as to enable such communities to overcome the inherent backwardness due to any historical, social, or economic causes, or any other acceptable and recognized cause. From the constitutional point of view, a benefit of reservation that may be meted to any enlisted, to any community would have to be understood for updating such community from its inherent backwardness. Cool, last line too.
The benefit of reservation that between many communities would have to be understood for uplifting such communities from its inherent backwardness.
From its inherent backwardness. From such constitutional concept, if the state enlists any community to be backward for the purpose of meting out the benefits of reservation, either as a scheduled caste, scheduled tribe, or other backward community, comma, a scrupulous and unbiased determination is also a requirement of the Constitution as to whether any person who claims to be belonging to any such enlisted reserved community do actually and factually belong to such community. in the circumstance, before issuing any certificate to any person that they belong to a particular community, which may be enlisted as a backward community, either as a scheduled caste, scheduled tribe, or other backward community. কি হলো?
Just account step for issuing any certificate to any person that they belong to a particular community. This may be listed as a backward community, not as a scheduled caste, scheduled tribe, or backward community.
Comma. There is a corresponding constitutional requirement for a thorough verification on the originality stroke
There is a corresponding requirement for a thorough verification on the originality.
a thorough verification on the claim of any such person, whether they actually and factually do belong to any of the enlisted community. In the absence of a thorough verification as to whether a claimant whether a person do actually belong to the community to which he claims to be belonging. In the absence of a thorough verification, comma, there would be a possibility that the persons who actually do not belong to such community would be issued a certificate, and based upon such certificate would claim and be entitled to the benefits of reservation constitutionally meted out only to such enlisted communities. In other words, if a person who actually do not belong to the particular community through any means obtains a certificate, comma, irrespective of whether the certificate is actually issued by the authority who is otherwise authorized to issue such certificate, comma, people.
In other words, a person who actually does not belong to the particular community may obtains a certificate, irrespective of whether the certificate is actually issued by the authority who is otherwise authorized to issue the
Comma, it would be a constitutional fraud. The Supreme Court, in its pronouncement, rendered in Kumari Madhuri Patil and another versus Additional Commissioner Tribal Development and others, reported in 1994 6 SCC 241. In paragraph 13 thereof, was of the view, is of the view that any admission wrongly gained or appointment wrongly obtained on the basis of false social status certificate necessarily has the effect of depriving the genuine scheduled caste or scheduled tribe or OBC candidate as enjoined in the Constitution of the benefits conferred on them by the Constitution. And the genuine candidate would be denied admission to educational institutions or appointments to posts or to office or post under a state The Supreme Court also took note that the ineligible or spurious persons who falsely gains entry often resorts to dilatory tactics or create hurdles in completion of any inquiry as regards the genuineness of the caste certificates. The Supreme Court also accepted the situation that the applications for admission to educational institutions are generally made by a parent, since on such a date, a student may be a minor. And in such circumstance, it is the parent or the guardian who plays a fraud claiming false status certificate. From the propositions laid down by the Honorable Supreme Court in paragraph 13 of its judgment in Madhuri Patil Supra, it is an accepted situation that even the Supreme Court had accepted the possibility of a constitutional fraud by such ineligible or spurious person who falsely claim to be belonging to a particular community which is enlisted for the purpose of reservation benefits under the Constitution. Change করিবা তোমার কি মান বেশি দীঘল বানাই নেকি তুমি কারণ মাজতে অলপ আৰু 5 মিনিট মান কৰিবা কারণ মাজত ব্ৰেকটো হৈছিল তো কি করব না লাস্টটো কি করব
Even the Supreme Court has accepted the possibility for by such ineligible or spurious
consider fraud. From the stand of the Secretary to the Government of Assam in the Social Justice and Empowerment Department, as well as the statements made by the Deputy Commissioner Karbi Anglong before the court, it has to be accepted that while issuing certificates to persons as OBC for availing the benefits of reservation under clause entry 24 of the notification dated 13/9/1993, no determination is made by the authorities issuing the certificates as to whether the person do actually belong to the tea garden Omogomo community, Sarita. And the certificates are issued merely on the premises that the applicant do belong to any of the 96 communities enlisted under entry 24. If a certificate is issued only on the premises that the person concerned belong to any of the 96 enlisted communities under entry 24, without making a tangible determination whether the person also do belong to the Omogomo category, comma, any such certificates that may be issued or sought to be issued and to be used for the benefit of reservation under entry 24 of the notification dated so and so, would have to be understood to be ineligible, spurious, as well as a fraud being claimed, or a fraud being committed or sought to be committed under a false status certificate. We have been told that the only examination that is done as to whether the certificate had been issued under the signature of the authorities authorized to issue the certificate. And as the certificates are issued by the authorities authorized to issue a certificate, therefore the certificates are termed to be genuine certificates. But without the determination in respect of a certificate to be used under entry 24 of the notification dated so and so, that the person concerned or his or her predecessor in interest also do belong to the Sarita Tigaranom community, comma, under the law, comma, as elucidated above, comma, it has to be understood that even such certificate issued under the signature of the authorized authority would be a false status certificate, meaning thereby that the person claiming the benefit of reservation under such certificate would be ineligible and also be a spurious person having committed a fraud. In a related matter where benefits of admission to the first year MBBS course was sought for on the basis of such certificates which were claimed to have been issued by the authorities authorized to issue such certificate, but without any determination as to whether the person claiming a person do belong to the Tigadanoma community. Ikolu. Comma. an order was passed requiring the authorities to make a verification through the state caste scrutiny committee, through the state caste scrutiny committee, as to whether such certificate holders do belong to the tea garden Omukom community. In respect of such order, Mr. R.M. Das, Land Counsel for the Social Justice and Empowerment Department, has produced an order dated 19/10/2023 in WA 390/2023 and other writ appeals, which is stated to be pertaining to the said order requiring a verification of the caste certificates by the State Scrutiny Committee. Full stop. We have perused the order dated so-and-so of the division bench in so. Upon perusal of the order, firstly, it is discernible that the core issue determined in the order dated 99 in WPC 19/9/2023 in WPC 5303/2023 regarding the requirement of a determination to be made by the State Caste Scrutiny Committee as to whether the claimant or the certificate holder do belong to the tea garden has not been disturbed by the division bench in any manner. All that the division bench ventured into as to whether the time limit provided in the order was adequate enough and was of the view that as per the judgment rendered by the Honorable Supreme Court in Komari Madhuri Patil Supra, a time limit of 3 months was given, and therefore the prescribed time limit in the said order was not adequate. We are not expressing any view on the said proposition of the division bench, other than referring to paragraph 13 of the judgment rendered in Komari Madhuri Patil Supra, that it is necessary that the certificates issued, status certificates issued are scrutinized at the earliest by the State Caste Scrutiny Committee and with utmost expedition and promptitude, by further providing that preferably such proceedings should be on a day-to-day proceeding basis if possible, but under no circumstance to exceed a period of 2 months. With a further 1 month time given to the respective candidates to object to any such view that may be formed by the State Caste Scrutiny Committee. In this respect, paragraph 13 of the judgment rendered by Supreme Court in paragraph 30 of the on Supreme Court economy is extracted as below. Other than the time frame referred above in Komari Madhuri Patil Supra, what is more relevant is the stringent observations and propositions laid down by the Supreme Court. that upon an ineligible or spurious person gaining false entry for an admission or an appointment in a post under the state, comma, it has the effect of depriving the genuine scheduled caste, scheduled tribe, or OBC candidate as enjoined in the Constitution of the benefits conferred upon them by the Constitution. In other words, an ineligible or spurious person, by fraudulently obtaining and claiming to be belonging to a reserved category community, would commit a further constitutional fraud of depriving a genuine scheduled caste or scheduled tribe or OBC candidate from availing the benefit of reservation which the Constitution had provided for them. Equal to. Equal to last sentence too. No, no, sentence to quote start করেছিল, so that I can continue the next one.
Other than the time frame,
কি?
other than the time frame, what
হেতু
what is more relevant is the use and advertisement.
What is no, the core provisions laid down by the core provisions here. Core provision is this constitutional fraud, not the time limit. Core provisions, core provision is that so and so. With a further provision that there is a necessity under the Constitution, there's a constitutional necessity that such certificates are scrutinized at the earliest and with utmost expedition and promptitude. The provision that the certificates are to be scrutinized at the earliest with utmost expedition and promptitude follows from the proposition that otherwise a genuine scheduled caste, scheduled tribe, or OBC candidate as enjoined in the Constitution would be deprived of the benefits conferred upon them by the Constitution. The principles of natural justice in respect of such ineligible, spurious, or fraudulent candidate as regards a determination of their social status by the State Caste Scrutiny Committee is protected. In paragraph 1310, in 13.9, that the decision that the State Caste Scrutiny Committee may take after the expeditious and, if possible, day-to-day proceeding should be communicated to such affected candidate within 1 month from the date of conclusion of the proceeding. And paragraph 1511 provides that the determination that may be made by the State Caste Scrutiny Committee shall be final and conclusive and only subject to a proceeding under Article 226 of the Constitution, meaning thereby the natural justice of such affected candidate would be protected by the copy of the report being made available, and such candidate may assail the same by means of a proceeding under Article 226, which again is circumscribed that no appeal shall lie against the order of the learned single judge in such proceeding to the division bench, and the appeal would be maintainable only before the Honorable Supreme Court.
Paragraph 13.
30, huh? 8, 13, 9 or 13, 11. Take it. And further, that such petitions under Article 226 would be disposed of by the High Court as expeditiously as possible within a period of 3 months. The period of 3 months, and I'll get that. What is further noticeable is that in paragraph 13 bracket 14, it is provided that in case the certificate obtained or social status claimed is found to be false, the parent stroke guardian stroke the candidate should be prosecuted for making false claim. And if the prosecution ends in a conviction and sentence of the accused, it should be regarded as an offense involving moral turpitude, disqualification for elective posts or offices under the state or the union, or elections to any local body, legislature, or parliament. Paragraph 13-14 is a very stringent provision laid down by the Honorable Supreme Court to eradicate the menace of ineligible and spurious persons making false and fraudulent claim for benefit of reservation under a falsely and incorrectly obtained social status certificate. Paragraph 13-15 of the judgment rendered by the Honorable Supreme Court in Kumari Madhuri Patil further provides that as soon as a finding is recorded by the State Caste Scrutiny Committee holding that a certificate obtained was false, comma, on its cancellation and confiscation simultaneously, comma, it should be communicated to the educational institution concerned or the appointing authority by registered post with acknowledgement with her due request to cancel the admission or appointment of the person relying upon such false social status certificates. And the Honorable Supreme Court enjoins it upon the principal, etc., of the educational institution responsible for making the admission or the appointing authority to cancel the admission appointment without any further notice to the candidate and debar the candidate from further study or continue in office in a post. The consequences of claiming and relying upon a false social status certificate is clear and explicit in the proposition laid down by the Supreme Court as noted above. And the provision appears to be a mandatory provision binding on the head of the education institution or the office where a person may have been admitted or working by relying upon a false social status certificate. Paragraph 14 of the judgment rendered in Komari Madhuri Patil further provides that it is for every state concerned to make an endeavor to give effect to provide for a fair, just, and fair and just procedure by shortening any undue delay to ensure that the constitutional objective intended for the benefit and advancement of genuine scheduled caste, scheduled tribe, or backward classes are not defeated by any unscrupulous person. Paragraph 14 is extracted as below. In the order of the division bench dated so and so in WA so and so and other writ appeals, a further view was expressed that a new criteria for verification of producing evidence from tea garden management was introduced, which had led to a travesty of justice being committed. The provision thereof as to what the state caste scrutiny committee is required to do is provided under in paragraph 13 clause 5 of the judgment rendered by the Supreme Court in Komari Madhuri Patil Supra. In paragraph 13.5, it is provided that the vigilance cell that each directorate is required to constitute shall examine the parent, guardian, or the candidate in relation to their caste, etc., or such other person who have knowledge of the social status of the candidate, and then submit a report to the director together with all particulars as envisaged in the pro forma, in particular of the scheduled tribes relating to their peculiar anthropological, ethnological traits, deity, rituals, customs, mode of marriage, death ceremonies, method of burial of dead bodies, etc., by the caste or tribe or tribal communities concerned. The said provision in paragraph 13.5 appears to be inclusive and not exhaustive. But the purpose is to determine the true status of the person who claims the benefit of a social status certificate. In respect of any other enlisted communities as scheduled caste, scheduled tribe, or OBC, the inclusive requirements provided by the Honorable Supreme Court in paragraph 13.5 would be relevant and also may be adequate. But in the instant case, we are concerned with entry 34 of the notification, 24 of the notification dated 13/9/1993, which has already been extracted herein above. And also where also a conclusion had been arrived that entry 24 is a entry which is inherently with a difference with all other entries in as much as there is a requirement of a twofold determination. That is, firstly, whether the person concerned belongs to Tea Garden, Tea Garden, Omo community. And upon a determination that the person concerns do belong to Tea Garden community, Omo community, a further determination as to whether the person belongs to any of the 96 enlisted communities. As to who may belong to the Tea Garden Exterior community had already been discussed and concluded that there is a requirement of a factual determination as to whether the person concerned or any of his or her predecessor was a laborer in any of the tea gardens in Assam. Entry 24 being of exceptional nature, where there is a requirement to also determine as to whether any of the whether the person concerned or any of his or her predecessor was a laborer in a tea garden in Assam, comma, for such determination, comma, there is also an inherent requirement to verify as to whether the person or the predecessor was a laborer in any of the tea gardens. And it is for the such purpose that an additional provision would be a constitutional requirement, comma, of course, confining it in respect of entry 24 of the notification dated so and so, for producing any further evidence from any of the tea gardens that the person concerned or any of his or her predecessor was a laborer in a tea garden. The division bench order is clarified to the aforesaid extent. Mr. Das, anything more? Okay. Do you think of anything more to be make it that all laws are complied with? So sorry.
Perhaps statutory provision by the state government. Just the last I got.
Which one?
Just noted that constitutional requirement for a verification whether they have belong to the.
No, this is a constitutional requirement. Reservation is a constitutional concept.
The statute would perhaps be required to the state government for that particular for the verification process. That much.
Supreme provisions of the Supreme Court guides the field, not what notification they issued from time to time. You cannot restrict yourself by a notification. And Supreme Court and the division bench, we are clarifying to this extent that for entry 24 alone, a further requirement is there to link up with a tea garden. For others, we are not saying so. That for every determination you go to a tea garden, we are not saying that. But specifically for tea garden, this entry 24, this otherwise you cannot determine.
Actually, your lordship, the fact that in some of the candidates cases, the SAR Samiti, the SAR Janajatiya Samiti itself has said that the certificates are not factual. That is there in my application.
Which page? Let
Page
us take a
number
note of that.
1, Annexure H.
That one is relevant.
Factual.
Page number
Page 144,
144.
Annexure H.
We have been told that some of the certificates relating to entry 24 of the notification dated pertaining to ex-tigger and homo laborer are also issued through the Cha Janajati Jatiyo Hanmilani, which is an apex body of the tea garden tribes. The Karbi Anglong District Committee of the Cha Janajati Jatiyo Hanmilani had made a communication to the communication dated 7/8/2023 to the Additional Deputy Commissioner Karbi Anglong, wherein it is stated that the subcast of some 9 applicants involved therein, like Chawan, Singh, Chaudhary, etc., are not found in T and ex-Tea Garden tribe community. And further, with a request to the Additional Deputy Commissioner not to issue caste certificates on the basis of father's caste certificate of the aforementioned caste, as it may be forged, which again may harm the tea garden community. We also take judicial notice of the aspect that there has been a confusion in the certificate issuing authorities. As per the statement of the Secretary to the Government of Assam in the Social Justice and Empowerment Department, as well as Deputy Commissioner Karbi Anglong, that materials being produced that a person belongs to any of the 96 communities enlisted under entry 24 so and so are issued certificates belonging to the tea garden external community merely upon such determination, without the core required determination as to whether the person or any other predecessor did work as a laborer in a tea garden. Last line too.
There has been a confusion in the certificate between both third party sections of the certificate, the government of Assam in the judicial, in the social justice and empowerment department, as well as the deputy commissioner, the materials being produced with person belonging to any of the 96 communities and under any sort of the notification.
By taking note of the aforesaid confusion, taking note of the aforesaid circumstance where certificates were issued without a proper understanding of the provisions of entry 24 of the notification data, there is a possibility that a large number of such certificates may have already been issued in the meantime, and ineligible and spurious persons are fraudulently enjoying the benefit of reservation under entry 24. In this respect, we take note of the provisions of paragraph 13, 1 to 13.3 of the judgment rendered by the Supreme Court in Madhuri Patil Supra. Which requires that the application for grant of social status certificate shall be made to the revenue subdivisional officer or deputy commissioner, and the certificate shall be issued by such officer. And further, that the parent, guardian, or the candidate, as the case may be, shall file an affidavit duly sworn and attested by a competent gazetted officer or non-gazetted officer with particulars of caste and subcaste, tribe, tribal community, parts or groups of tribe or tribal communities, the place from which he originally hails from, and other particulars as may be prescribed by the directorate concerned. In this respect, the directorate concerned for determining the acceptability of a social status certificate under entry 24 of the notification dated so may further prescribe the requirement of establishing a link with any tea garden laborer in link with a tea garden laborer in any of the tea gardens in Assam. But what is more relevant is the provision of paragraph 13.3, which provides that an application for verification of caste certificates by the State Caste Scrutiny Committee shall be filed at least 6 months in advance before seeking admission into an educational institute or an appointment to a post. You are here in this matter?
No matter.
Some other matter. The said provision appears to be a general provision that all caste certificates that have been issued shall, by an application by the certificate holder, be sent for a verification by the State Caste Scrutiny Committee, which is a requirement to be done 6 months prior to any admission or post. Paragraph 13.6 provides that the authority making the inquiry shall give reasonable opportunity to the candidate, parent, guardian to adduce all evidence in support of their claim for their social status certificate. But paragraph 13.15 is further relevant, that upon undertaking such inquiry by the authority, which is understood to be the State Scrutiny Committee, and an adverse report thereof being submitted, it is also incumbent upon the principal, etc., of the educational institute or the appointing authority to cancel the admission appointment without any further notice to such candidate and debar such candidate from further study or continue in the office. The respondents in the Social Justice and Empowerment Department to also take note of the proposition laid down by the Honorable Supreme Court in paragraphs 13.1, 13.3, 13.6, and 13.15 of the judgment rendered in the Supreme. And it is expected that the constitutional requirements would be duly complied with by the department. In the facts of the present case, as it is a writ petition seeking for a direction for issuing a social status certificate to the petitioners, we accordingly require the petitioners to make an application to the revenue sub-regional officer or deputy commissioner, as the case may be, as provided in paragraph 13(1) of the pronouncement of the Honorable Supreme Court. Then all your other laws goes. They are possibly impliedly interfered by the Supreme Court, all the notification, everything. And upon such application being made, the respective revenue sub-regional officer or deputy commissioner to give a due consideration to such certificate, make a factual determination on the entitlement to the social status as may be claimed. And if it is in respect of a social status under entry 24 of the notification dated so and so, to also undertake the necessary exercise and also undertake the necessary exercise of arriving at a factual determination as to whether the person concerned or any of the petitioner was a laborer in any of the tea gardens in Assam. And such certificates that may be issued be subjected to a scrutiny by the State Scrutiny Committee by scrupulously following the complete procedure laid down in paragraph 13 of the judgment rendered by the Supreme Court in Kumari Patil Supra. Considering the urgency of the, we have also taken note of that the petitioners are being admitted in the respondent Navodaya Jawahar school by virtue of interim orders of the court, which requires finality to be finality to be made upon such provisional admission. The respondents are required to forthwith apply for all such certificates, which the Deputy Commissioner shall do the needful and either issue or decline to issue by following the due procedure of law provided in paragraph 13 of the, and also taking note of the clarifications provided in this order as expeditiously as possible. Now again, we don't fix any timeline. We'll go to the thing that I want 3 months. As if ever way. Upon the same being done, and if aggrieved, no, the same being done, it shall be verified by the State Scrutiny Committee under, as required under paragraph 13(3) of the judgment rendered by the Supreme Court. And thereupon the report be provided to the respective candidates for doing the needful as may be required under the law. But time will meet, what do we do? If they don't, if the applicants do not approach the Deputy Commissioner within a period of 15 days from the date of this order, the interim order passed earlier shall stand recalled. But Deputy Commissioner, we can't fix any timeline now. Somebody will say it's a travesty of justice.
Perhaps a timeline that might be
As indicated. And that's why we understand what
they
to
will
do.
lose a 1 whole year in case.
You're also losing. Suppose it goes against you, we'll lose 1 year.
It is a state level task scrutiny committee.
Let's do one thing. Should I modify to some extent that instead of making a deputy commissioner, directly to the, you appear before the state scrutiny committee with relevant meeting. Ki kolo last sentence to? No, lage. Tar agor kini is a kolo je deputy commissioner under 13(1). Although, although as per paragraph 13(1) of the judgment rendered by the Honorable Supreme Court in Mandhuri Patil Supra, but we have taken note that by an interim order of this court, the petitioners have already been provisionally admitted in the respondent's own school, Navodaya school. And therefore, there is a urgent requirement to make a determination on the social status of the petitioners as claimed. To expedite the matter, instead of following the procedure of making an application to the respective subdivisional officer or deputy commissioner as provided in para 13(1), we require that the petitioners may directly approach the state scrutiny committee, produce any relevant materials before the committee to substantiate their claim that they belong to the ex-tea garden community. And if the committee is of the view that the petitioners do belong to ex-tea garden community, a report thereof be provided to the petitioners, and based upon such report, the petitioner may approach the deputy commissioner for formally issuing the certificate.
They already have certificates.
So he says, no, look at the prayer.
The Lordship say the problem is that they're submitting certificates which are not genuine. That was the word.
No, but look at the prayer. Prayer is to issue certificate. We'll come back at 2 if there is there. I've gone by the prayer of the petition.
I stand corrected. One of them
Uh,
does have a, do
Uh,
not have a certificate. Some of them have, some of them don't.
It is stated by MS Aristotle and counsel for the respondents in the Navodaya authority that some of the petitioners had submitted certificates issued by some authority, which according to the respondents are not genuine certificates. In respect of such petitioners, they also to approach the state scrutiny committee along with the certificates relied upon by them, and the committee will make a determination on the social status as strictly as per the provisions in Komati Matis Patil Supra.
Time frame means within how much
In
time?
15 days, they will approach the,
The approach, the petitioners to make the approach within a period of 15 days from the order, and if even the approach is not made, interim order passed earlier shall stand recalled.
Okay. State level caste scrutiny committee.
Sorry,
State level caste
a
scrutiny.
state level class is what correct.
From now onward, the tea garden issuance of caste certificate on tea garden will this principle be followed?
I don't know. If there is a Supreme Court and there is a government notification,
Yes, there is
I think at least we are more bound by the Supreme Court.
Lordship. That is.
Then your notifications, you modify them to make it in conformity with 13(1). I think that's a better way out. Otherwise, there's a lot of confusion. Time to time, all people are issuing different notifications, and actually, what is that originally I know the history of this. It started with the deputy commissioner. Deputy commissioner doesn't know whether a man belongs. He started taking views of the different kind of associations and this and that. After some time, why it happened, I don't know. The law was changed that this association will issue the certificate and it will be countersigned by the deputy commissioner. Law was reversed. But that reversal is in conflict with the Supreme Court judgment. So we follow Supreme Court.
Your Lordship mentions then it,
Sorry,
if your Lordship mentions in the
we
order,
cannot unless the notification is challenged. Again, it will say it is without jurisdiction. So what we provide is we go by Supreme Court. 15 days apply, otherwise interim order goes. List again after the report of the state level scrutiny committee is made available.
Can I make a humble submission? In the meantime, the principal of Tiku, the one he is harassing these petitioners. He is telling the other students not to talk with them because they secured their admission through an intelligence.
Definitely you are a possible fraudster.
Not to-
So the principal thinks I should protect the genuine students. First you get yourself
Yes, yes.
verified.
Okay.
Principal may be a little wary of the fraudulent people. Don't talk with them. You'll also get spoiled.
Ultimately, they are mentally harassed.
No one is mentally harassed.
The students.
You should have done it at the earliest. It didn't require a court order for this purpose. Yes, Mr. Churi.
Well, the company matter lots of speak.
Mr. Mishra was there. As I was dictating an order, I knew it.
For little, only for tomorrow. Today, actually, second half, there's a Shraddh ceremony of my family. I have to go. Tomorrow, my lord, I'll just require half an hour time.
Tomorrow, 46. 46 in a civil bench, the second appeal, first appeal, it takes a long, long time.
Tuesday.
Tell Mr. Mishra also.
Yeah, we also already
Yeah,
informed
that's
regarding today's.
Okay. We'll pass it.
Can Miller time to withdraw that?
Will be called.
Item 20.
The officers have come from finance PRU as well as from the accounts department of the High Court.
No, this after the event, the whole report is available. No. Please come to page 37. Please explain your calculation of on what basis this calculation is made.
My lord, the petitioner was holding the post of stenographer.
No, we don't want what he was holding. On which date the revision of pay was given effect?
Yes.
On which date? Not yes, which date?
That is, date of effect is 1/4/2016.
1/4/2016.
2016.
Not which date it was given effect, on which date it was implemented.
The ROP was published in 2017, March 2017. Date of effect of ROP is 1/4/2016.
That is a retrospective effect. We are not asking on retrospective effect. From which date did you implement it? There is a difference between retrospective.
Yes, sir.
Today I am getting rupees 200. Okay. And my 200 is retrospectively extended to 400 from 1/1/2023. So from 1/1/2023, I'll get 400, although today I'm getting 200. So what is that today's date? On which date you implemented revision of pay? বুজি পোৱা নাই retrospective effect দিয়া আৰু কোন দিনাখনৰ পৰা তাক হেৰি কৰিছে দুটা বেলেগ কথা কোন দিনৰ পৰা কৰিছে
Actually, this ROP is
not actually date এটা তাৰিখত কৰিছে তাত কোনো actually কথাই নাই কোন তাৰিখৰ পৰা আপোনালোকে নতুন পেটো ইমপ্লিমেন্ট কৰিছে
Yes. 17 March 2017.
17 March 2017, this person, what post he was holding?
At that time, he was holding the post of stenographer grade 1.
Grade 1.
Yes.
So on the day it was implemented, what was his basic pay?
At that time, his basic pay was 19,100.
19,000.
Yeah.
So 19,000 যদি তেওঁৰ basic pay হয়, আপুনি pay to revise কৰে, 19,000 ৰ equivalent যিটো revise pay তেওঁ সেইটোহে দিব। হয় নে নহয়?
So, Lordship, আমি যিটো
আপোনালোকে বেলেগ কৰিব কিয়? এটোতো আপোনাৰ মৰ্জি নহয় যে মই এনেকে কৰিম বা তেনেকে কৰিম। সবকে যেনেকে দিছে তেখেতকো একে কৰি দিব। এক নম্বৰ কথা। 2 নম্বৰ কথা, এজন এমপ্লয়ী আজি এটা বেসিক পে পাই আছে। এই পেটো আজিৰ পৰা ৰিভাইজ হ'ল। ৰিভাইজ হলে তেওঁ সেই পাই থকা বেসিক পেটোৰ ইকুইভ্যালেন্ট যিটো ৰিভাইজ পে তেওঁ সেইটোহে দিব। তাতে আপুনি এই বেলেগ ধৰণৰ অংক এটা কৰি তাকটো আপুনি বেলেগ কৰিব নোৱাৰে। That is a basic নিয়ম। That's a basic rule. You cannot deviate from that. And why will you make all these funny calculations?
I am not dealing this matter, my lord.
So we required a matter who is dealing with it. Then why did you come before the court? আপুনি নালাগে আহিব, যোনে কৰিছে তেওঁক আহিব দিয়ক।
Sir, dealing assistant.
তেওঁক আহিব দিয়ক তেতিয়াহলে। কিয় কৰিলে এইটো অংক আপুনি?
স্যার এইখিনি মই দিব নাছিলো, কিন্তু আমাৰ গোটেই হাইকোৰ্টৰ এমপ্লয় বিলাকৰ যি ৰিভাইজ হৈছিলে 1/4 ৰিভাইজটো হৈছিল।
নহয়।
1/4
They
ডেটতে
call the register. I'm unable to get along with these people. They are not understanding anything. They are not giving any reply. There is a, Mr. Das, there is a difference between a retrospective effect being given to a revised pay and the date on which it was implemented.
I understand your lordship. Your lordship
So,
wanted to know-
so on the date the revised pay was implemented, how will you give the revised pay? You take note of the basic pay paid to that employee pre-revision. And whatever was the basic pay, equivalent to that, whatever is the revised pay, you'll give it that. And how will you give it? If you give it effect from 2016, that will be given from 2016.
But in fact,
Number
what-
one.
What procedure is followed?
Why will you follow a different procedure?
No, it's not a different procedure. It's a universal procedure for all the employees of the
Are you
government.
sure?
Yes, my lord, that I'm sure. I have got the record.
If I call for the records of all the employees in the High Court,
Yes, my lord.
you'll be in contempt. Bring the record of all the employees of the High Court.
My lord, so far as fixation.
Mr. Das, I'm warning you, based on certain factual inputs we have,
My lord,
that you are, that's an incorrect statement. You are going only by instruction given by these people.
no, apart from their instruction, my lord, I have also seen the record, my lord.
Produce the record you have seen. Let us see. Let us see whose record, which record you have seen.
My lord, these are the pay fixation records of employees. Your lordship will find
Mr. Das, I'm telling you, you are leading.
what they do is, I'm just placing what they do, what they have done, my lord. What they have done, I am just placing.
They have done it page 737. It is before us. You don't have to explain.
No,
We have read it.
If I may place, my lord, one document before your lordship, they have. My
Which
lord, prepare
document?
a Gist
See.
of, just gist of the calculation, my lord. If your lordship kindly appreciate this one for one moment. Here, you have some photo. My lord, even if the,
No, we don't understand all this.
I'm just
See,
explaining, my lord.
Mr. Das, none of us has studied commerce accountancy. We only go by law, we go by logic. These are absurd.
If we go by the ROP rule also, my lord, this is in conformity with the.
Which ROP rule? Let us point out.
2017.
See.
Oh, that is-
Mr. Das, we are again telling you,
my lord.
verify your facts first. You may be wrong. And when we say something, there is some meaning to it.
I understand. My lord, I'll again verify, my lord. I'll again verify. If
Please
the-
do verify.
Yes. I'll
And
again
which
verify.
rule you are relying on? Tell us.
My lord, if your lordships kindly take this chart, I'll just.
See, unnecessary, you're putting this man in contempt, I'm telling you. They have possibly not realized what they are saying. Take note of it.
Lord, I'll verify the record.
Now, which rule you are saying?
If your lordship kindly take up the Assam Service Division of Pay Rule 2017.
Rule number. Which rule, which
Well,
procedure
first-
you are referring?
1B comes, it says from 1st April 2016, it will be applicable.
Mr. We are not interested in history of that
Yes,
matter.
yes,
Which
yes.
rule you are referring?
Rule 5,
Rule 5. Yes, what is Rule 5?
application of the revised pay.
Hmm.
Save as otherwise provided in this rule, a government employee who is in service on 31st March 2016
Hmm.
or who may have been appointed on or after 1st April 2016 shall due pay in the revised pay.
Mr. Das, this is the provision of retrospective implementation effect.
Yes.
Okay, we understood. Then next,
Then
which rule allows you to make the calculation as made in page 37?
Rule 11 is the
Very sternly, you made a submission. We follow the
Yes.
rules. Which rule? Let
Rule
us examine.
Rule 11 is with regard to fixation.
We don't want anything else. By following the procedure prescribed in which rule, you have made the calculation of page 37.
Rule 5 and Rule 11.
Rule 5 is nothing, doesn't help you in any way.
Well, Rule 5 says that on 1/4/2016, the pay will be revised. Whoever in what pay as on 31st March 2016 was there, his pay will be revised from 1/4/2016.
Very well.
That is the first, this chart, if your lordships kindly take up, it says, it provides how the, on 1/4/2016, how the revision was made. If your lordships kindly see, Hasnain Alam joined the registry stenographer grade 2 on 23/3/2012.
Very well.
Pay scale 8,000, 35,000, grade pay 4,300 plus principal seat pay 1,000. Then on 1/7/2013, and his total basic pay comes to 13,300. That is 8,000, 4,000 and 1,000.
We have read it. We are asking you why. There is a difference in the question. One is, I have not understood, I am unable to read. You are trying to help me in reading it.
Not at all.
And I don't think that is your purpose.
No.
We are asking you why we have made this figure 37,160. By following which procedure, which rule? And don't be evasive.
Lord, if your lordships kindly.
Mr. We are explaining you once again.
Lordship.
Please listen carefully.
Well.
This man admittedly, this revised pay came into effect from March, on 17 March 2017.
Yes.
How will you determine the revised pay to be paid? On 17 March 2017, whatever pre-revised basic pay this person was getting, in whichever post he was holding, okay, the equivalent of that basic pay in the provision for the revised pay, he will be entitled to that. And there cannot be any other meaning. Okay. So, this man, without the PSP, was getting 12,000 pay band, 5,900 grade pay. Total comes to 17,900. Your own page 36 says basic pay of this category employee will be grade pay band plus grade pay plus PSP. PSP is 1250. So you add 1250 to 17,900. That comes to 19,150, I suppose.
Yes.
It comes to 19,150. So when this man was paid a basic of 19,150 on 17 March 2017, when you revise his pay, it will be the equivalent pay, revised pay corresponding to 19,150. Come to page 40. Corresponding to 19,150 is serial 4, 19,570. Equivalent is 47,320.
That is their case, my lord.
Not their case. That is the as per law.
Look, with all the
And how can you deviate from this calculation and adopt a different method? By repeatedly I'm asking, by following which provision of law? Show us, we'll examine that provision. We don't want anything else from you. And mind you, this is the 10th or 11th day we're hearing the same matter, same answers I'm getting from you. Show us that this is the mathematical formula provided under this provision of law. We have implemented it.
People also kindly take up rule 8 for a moment.
8, okay. Yes, what does rule 8 provide? Law is very clear. Read it carefully.
Yes.
Initial pay of a government employee who is in service on 31st March 2016. So this man must be in service as on said date.
Yes.
And is entitled under the rules to draw pay in the revised pay structure.
Yes, ma'am.
This man is admittedly entitled.
Yes.
Shall, unless the governor by special order directs, otherwise in any special case, be fixed on the day he becomes so entitled. The date of becoming entitled is 17 March 2017. To be given, this is where you are going wrong.
If I have understood correctly, my lord.
No.
Because we cannot skip the stenographer grade to my lord, the portion. When he was on 1/4/2016.
Mr. Das,
My lord.
this is where all your cobwebs are coming, of your employees. Date he becomes entitled is the day revised pay was notified. Prior to this date, he is not entitled. What he is entitled under Rule 4 is, it will be given effect from 1st April 2016. There is a difference between the word effect and the word entitled. Because as on 1st April 2016, as on that date, he was not entitled. He was not entitled because there was no revision of pay rules existing as on that date. He became entitled only on 17 March 2017 when these rules were adopted. This is how a statute is to be interpreted. You cannot give the meaning of the word giving effect and give the same meaning to the word entitled. They are absolutely two different meaning and different circumstances. Explain your employees. And when you will determine the revised pay he will get on the day of entitlement is what, or is it pre-revised pay he was getting on that day. Find out the equivalent revised pay. He will get it. Your case is between 1st April 16 and 17th March 2017, This man was promoted from grade 2 to grade 1. So while calculating the revised entitlement of the revised pay, you will not take what he was getting on 1st April 2016 as a grade 2. What you will do is, you will take the figure he was getting on the day he became entitled, calculate his equivalent revised pay. For giving retrospective effect from 16, from the day he was promoted from grade 2 to grade 1, you will be calculating what he would have got as a revised pay on the pay he was getting as grade 1 from the day of the promotion. But definitely he was promoted after 1st April 2016. So there will be a gap period between 1st April 16 and the day of promotion, the day he was a grade 2. Then we'll find out as a grade 2 what he was entitled and give him the revised pay of that grade 2. I'm giving you two further instances. Suppose this man would not have been promoted. He continued in grade 2. What would you have done? You have calculated his revised pay on the day of the entitlement, 17 March. Give him the revised pay. For the retrospective effect, whatever pay he was getting on those months, what correspondingly would have been the revised pay? The balance you pay, even we got it. Even we got that revised pay. Because the effect was given for 17 March, but we are entitled from 1st of April 16. So between 17 March and 1st of 16, whatever pay we are getting, the equivalent revised pay was given and the balance was given to us. It's given to every employee. Fine. So this is how we will calculate it, not taking all these absurd calculations. This is number one. Number two, suppose this man would not have been promoted had he been a grade 1 since before. Okay. Suppose there is no PSP, nothing. Take the simplest of the case. Then on the day he became entitled, he was getting 12,000 plus 5,900, 17,900. So minus the PSP, if you come to page 40, he will be at serial number 1 of the fitment. That is 43,300. So minus the PSP, he would have got 43,300. But with PSP, now he'll get 37. PSP is a negative entitlement or a positive entitlement? Is it a minus something? PSP is minus 2,000. No. Then how can it be less? No kind of common sense makes it acceptable. Invariably, the calculation at page 37 is wrong. Some wrong parameters were taken note of. And now I can understand from your argument from Rule 5 and Rule 8, there's a mix-up of these persons making the calculation of the date of entitlement and the date of effect, retrospective effect.
Look, so far as second example given by your lordship, I am in agreement with that, my lord. That's how the fixation is done.
So without
get
PSP, the
area.
man would have got 43, but with PSP, now he's getting 37. So you have given an additional benefit, which is negative in terms.
ROP came in March 2017. ROP came in March 2017. And
And
gave its
Mr.
effect-
Das, for your information, every employee in the High Court, including the judges, their calculation is made of the revised pay as per the date of entitlement, that is 17th March. 17th March, whatever pre-revised pay, I think Mr. Gogo will agree with it. Whatever pre-revised pay was given to anybody from top to bottom, he was given the equivalent revised pay from that date.
That equivalent revised pay would be arrived when your the employee's pay is revised from 1/4/2006 and getting increments.
Mr. Get
Look,
out,
what amount
Mr.
I-
Das, take out any proposition of law where the date of retrospective effect and date of entitlement is held to be same.
No, just for an
Stop this,
example, I'm just giving you.
Mr. Das, I'll debar you from making these absurd submissions. Please don't. We had enough of it. We have enough of these submissions. Repeatedly for the 10th or 11th day today now. Please stop it. There is no legal interpretation of a date of entitlement and the date of retrospective effect to be the same. You can get any legal advice from anybody and come back and tell us. And if yes, under which proposition of law? And the calculation of page 13 is taking the date of entitlement to be 1st of April 2016.
Not if the, sorry, my lord, if the date of entitlement of that particular person
Is 17 March 2017.
but we'll have to revise his pay from 1/4/2016.
No, that is retrospective effect. You'll have
Fine,
to
my lord,
revise.
fine. If he is getting on 1/4/2016, whatever pay he was getting, that has to be brought under ROP 2017, my lord. And that calculation will follow till his date of promotion.
Very well.
On promotion,
Huh.
on the date of promotion, the revised pay rule is already there. Because of its,
What is already there?
no, I'm just placing when he got the promotion,
No, see, I'm
we
reading it once again. I'm finding it absolutely absurd.
Lordship will kindly
Just
come to
come to page 37. You don't test our patience anymore. Come to page 37.
yes,
Date on which clause 5 revised pay structure is applicable 1/4/2016.
Yes.
You are right. Applicable.
Yes.
Not entitled.
Fine.
Entitlement is when existing pay structure 8,000. Okay.
Yes, my lord.
Basic pay in the revised structure 14.
Yes,
Very well.
yes, my lord.
So now you 1400.
14,550.
14,500. Okay. Now, what is equivalent to 14,500 after revision?
27,060.
27. So up to the date of the promotion in grade 1, his will be 27.
27,060.
27. We accept that.
Yes.
Till here it is right.
Yes.
Now, what is clause number 9? Grade pay 900.
27,060. Grade
So,
pay is
no.
9,100.
After this man was promoted, he is in a different scale of pay.
True.
It is nowhere connected with the grade 2 pay.
True, my lord.
So on the day he was promoted, he is in pay band 12,000 plus grade pay of 5,900.
Yes.
Comes to 1700, 900.
Yes.
Plus PSP of 1250.
If
So he is 19,150. So for the promoted post of grade 1, his fitment will be as per 1950. Whatever is the equivalent. 1950 equivalent is 47,000.
Not 19,150 is corresponding to the pre-revised scale of grade 1. But ROP
See,
rule
Mr. Das,
2017
for the period this man served as grade 1, up to the date of entitlement of 17, his revision will be on grade 1 pay.
Fine, my lord.
Not, it is absolutely unconnected with grade
I'll
2.
just try to.
For the period he was serving as grade 2, his revision will be as per grade 2.
My lord will kindly
will not,
hold one paper, my lord, this chart that is.
chart is absurd, I told you.
I'll just take, I'll just
That's it.
place it once more before your lordships corresponding to page 37.
We find it absolutely absurd, nothing else.
Lordship will kindly revise pay as on 1/4/2016. Lordship will kindly have 22,000, 97,000, grade pay 9400, 1,000.
Forget about this page. Now you explain me clause 11, revised basic pay is 37. How it can be?
37,160.
How revised basic pay as grade 1?
Yes.
How can it be
No, it's not grade 1. It's grade 2.
grade 2? Grade
Grade
2, you go on paying him anything.
This is grade 2.
Grade
This
2.
37,160.
So from after grade 1, what is he getting?
Sorry, my lord.
After grade 1, what is he getting?
Lordship will kindly come to the chart, my lord.
Hmm.
On 23/1/2017, joined as private secretary, 30,000, 1,10,000 is the pay scale. This is the revised pay scale, man. Grade pay 13,300. It's not
So he's
12,000.
coming to 44, 550.
Yes, my lord.
Ah.
How this 44,550? Lordship will kindly see the remarks. Basic pay 38,640. Then promotion increment. He gets one increment when upon his promotion. That is 1,160. And grade pay difference. Upon promotion, his grade pay will be changed. So the difference of the grade pay he gets.
What difference of the grade pay he gets?
Yes,
Why difference?
9,400 grade pay.
Upon promotion, he'll get only one thing. See, upon promotion,
Yes,
this man, he will be in the pay band of 30,000
Yes, my lord.
because that's a beginning.
Beginning.
Day he's promoted, he'll get the beginning. He'll not get anything more than that. Plus, what is the equivalent grade pay? 13,300.
Grade pay, yes, my lord.
13,300. So it will be 43,300.
Earlier he was 9,400. Now upon promotion he gets 13,300.
And PSP.
PSP 1250.
Why do you say he is in this payment of 30,000?
Sorry, my lord.
Why do you say he is in the payment of 30,000?
30. Upon promotion, my lord. Grade
Why?
1.
Why?
Yes, my lord.
No.
The previous pay of 12,000 and
No. Before revision, this man is in the pay band of 12,000. Okay. Before revision, he is 12,000, admitted.
yes, 8,000, 35,000. Grade 2.
This is of grade 1.
Grade 1.
23,1 is of grade 1, not of grade 2.
Yes. Yes.
So
Lordship
he's
is correct.
so he is 12,000. Pay band
Pre-revised is 12,000.
12,000. Grade pay of 5,900.
Fine, man. Correct.
17,900.
Yes.
Very well. It has to be.
Yes.
Unless somebody had made a wrong calculation.
Yes.
Plus PSP 1250. Add how much it comes to?
19,100.
19,100. Without PSP, he would have been 17,900.
Fine.
And his fitment would have been 43,300 revised pay. With PSP, it is 19,150. His fitment is 47.
Lord, the problem where is coming is that they are making the calculation on the basis of pre-revised. That 19,100.
It has to
is,
be. Mr.
But that
Mr.
pay has already been revised, my lord.
Mr. Das,
Yes.
your calculation method is still wrong. We are telling you, correct it. And we can't waste so much of time for this. There is absolutely no basis to take the pay band to be 30,000.
The reason why this pay band was taken as 30,000 is that ROP rule 2017, that 12,000 pay has been revised to 30,000, 1,10,000. So when his fixation will be made upon promotion, because 1/1/4/2016, his pay has been continuously revised under the ROP rule 2017 when he was on grade 2. Then he got promotion. When we do the fixation,
Forget about the promotion. Promotion is clear.
fine.
No difficulty with
So
promotion.
when we,
After grade 1.
We'll have to revise his promoter
So,
post.
on the day he was promoted,
Yes.
what was his pay band in grade 1?
After revision
No,
or actual?
before revision.
Actual pre-revise is 12,000.
500, 12,000.
12,000 to 40,000.
40,000. So, start at the beginning, it is 12,000.
Yes.
Okay. Grade pay.
Grade pay pre-revise was 5,900.
So, he is a man of 17,900.
Yes.
Okay. So, whatever is in this table 1.22 of 17,900, upon revision, he'll get that.
Yes.
You don't have to go into any complicated equations. That's why these tables are made.
Excluding PSP, yes.
Excluding PSP.
Yes, yes.
Now
Logic
you
is correct.
include PSP.
Yes.
It comes to 19,150.
No, that is exactly what has been done.
Then how
They are
you're
saying it
then how
on
you're
the
fee?
they are saying it on the pre-revised thing. We are placing on the revised thing what has been done.
Then
Yes,
how
but-
then where is the difference of figures then?
There is no, in fact, the
Then you pay no revise. You pay 47
can-
320.
Lottery will kindly see
Enough of it.
One
Mr.
more-
Das, enough. Pay
one
for
more
47 300. Which has been, to our information, paid to almost all the employees.
with all due respect, my lord.
With all due respect, we are telling you, and with due respect, we are telling you the likelihood of a contempt for making a false incorrect statement.
My lord,
After verifying certain figures, we are telling you. Maybe your man is not giving you all the figures.
Lord, may I take
Produce the revision of each and employee, of equivalent employee of this man.
one
produce it.
opportunity? Yes,
Get it. Entire complete register, get it.
Lord,
We'll verify.
that will be-
Hmm.
Mine.
You'll be in difficulty.
I'm submitting, my lord, whatever is.
Submission is not the only
I'm,
thing.
Whatever is
Hmm.
before me, my lord. I'll
Tell them.
try my best to clarify each and every point.
Different procedures are adopted for different employees.
That could not be done
It
efficiently.
should not be done.
That,
This is why we were asking you so sternly.
I'll be, lord, I'll definitely
Verify it.
everything before you, lord.
Hmm.
I'll produce the entire record. One opportunity, lord, you will give me. I'll come up with the clarity.
Or the, may I submit one?
Yes, please.
If the finance and accounts officer, Bao is of this honorable high court, especially
Which
he
Bao?
will, I don't think so, he is the finance and accounts officer who is the head in calculation, then would have been in better position to explain.
Definitely, we are not at all
yes.
happy with what is stated. What Mr. Das is doing is trying to justify what he has stated.
Because I was.
You are not helping us anything beyond that. Other trying to justify what you have already been stating for the last 10 days.
Prior to.
And that we have
I
already
was getting
found it
that.
quite unacceptable. At least for this paper you have given me, we see no basis of taking it to be 30,000. Why you know? Mr. Das, where you went wrong, you know. Suppose it is 30,000. Okay. Grade pay is 13,300. Total comes to 43,300. 43,300.
Yes.
without the PSPO.
Yes.
Come to serial number 1 of page 40.
Yes.
It is exactly 43,300.
Yes. That has been done.
Now you are adding
PSP.
PSP. Now come to page 33.
Page 33.
Basic pay is basic, that is pay in the band, grade pay plus PSP.
Yes.
So this PSP factor was added before the revision.
Already.
It is not that only after revision, it is added
Already
before
grade
revision.
2 itself. Yeah.
Before revision, this figure is 17,900, mind you, 12 plus
Yes.
599.
Yes.
Okay. Then of that you find the equivalent of 4300 at the PSP, but the PSP is not to be added now. PSP is already added. PSP is added to 12,599 plus 1250. That comes to 19,150.
In fact, my lord,
So moment it is 19,150, it will be serial number 4. It will not be serial number 1. This is what they are trying to say.
yes. In fact, my lord, the difference in the PSP is added. Earlier PSP he got
No,
9,000.
nothing.
Then the next.
No, don't add the difference. Add the actual PSP.
Fine, my lord. Even then, it comes to this 44,550.
Does not come.
So, lord, kindly appreciate one more, my lord.
Sorry, we can't accept. Because page 33 provides basic pay will be inclusive of PSP. And what you are doing is you are revising it minus the PSP and later on adding the PSP.
That is the procedure.
Is it applied to everyone? Check up and tell me.
That's why, my lord, we are not getting that particular fitment in the table. Because in the ROP rule,
Understand, are you applying it equally for all the employees?
yes, this is the procedure followed.
It's a statement. File an affidavit, will be subjected to contempt and verification of records.
I'll check the records, man, and then I'll
Check
come
up
up.
properly.
Yes, ma'am. I'll check up, my lord. Lordship will
Page
give you one chance.
37 will clarify, lordship.
You
Page 37 of my
We are-
petition will clarify.
check up carefully,
37.
Mr. Das.
37 will say
You are
that.
repeatedly saying thing and we are warning you repeatedly. And there is
I
a
understand, my lord,
meaning
I'm
and
taking-
purpose behind the warning.
I understand, my lord, I'm taking
If you are-
valuable time, my lord.
If you are across the board following the same formula, that for fitment will deduct the PSP for the time being, make the fitment and then again add the PSP. If you are following it across the board, we accept it. But if you are doing it in respect of few of the employees and in respect of the others, you are following the other formula that the basic will include the PSP and then make the fitment. Follow it for this employee also.
My lord, if the second one is correct, if I verify the record, if the second one is correct, my lord, I will concede before your lordship that I am wrong.
Get the records.
Yes. You get-
Get the records.
Yes.
Get it now only. It must be here only. We'll take up after some time.
Some records are there before your lordship.
No, we don't want some records. Get the complete records of all the employees.
One opportunity, my lord. Any other thing?
Obviously, we're getting. Office is here
That's true,
across
my
a few rooms. You have to just ask somebody to get it.
lord.
Ask
I'll
your-
have to check also. That's why I'm asking. Otherwise, I would not have asked.
So in other words, you are making a statement without checking.
No, my lord. Some records I have checked.
You said I'll have to check now.
No, your
So, but
lordship
you
has
are
said
very
about all the
vehemently you are
employees.
saying it is going on.
Lordship has said about all the employees of the High Court. All the employees I did not check.
Which of the employees you have checked up? Tell me,
Lord,
give
in
me
the
that.
record is there, my lord.
Which record?
I have given one
You have
record.
not given any record to us.
Oh, sorry, my lord. I'm sorry.
Mhm. How many employees you have checked up and what are their names? You have the record of anybody? Any sample record of any other employee? How it is calculated? You don't have to reveal the name, just a calculation.
My own calculation is that.
I don't want your calculation of any other employee. Do you have it with you?
Of the record, I have one of my.
Let us see.
colleagues.
No, just take a look at it.
Of the record, I don't want to.
Definitely, of the record. So we don't take the name, note of
Yes,
the name
Lordship.
also.
Yes, Lordship.
See, Mr. Das, one employee was in the pay band of 17,140. Okay. Pre-revised, huh? 140 pre-revised. Take note. Grade pay is 5900. So total comes to 23,040. Very well. This employee is also entitled to PSP 1250. At 1250 to 23,040. It comes to 24,290. This person has been given the revised pay of 59,980.
No, what is the pay band?
Benson, forget about it. 59,950.
950.
Come to page 40. Pay band is there, you can tell you. So now, had this employee been in the basic of 23040, the person would have been 2304, would have been at serial 10. Check up page 40.
Yes, I have.
Serial 10.
Yes.
Revised is 56530.
Yes, ma'am.
Very well.
Yes.
Now, as PSPO of 1250 had been added, this employee now comes to this employee now comes to
57,780.
No. This employee now comes to grade pay of 24850. Serial number 12. Right or wrong?
Yes.
Serial number 12, this person comes to?
Lordship is adding 1250 with 23,410.
So now will be covered by serial 12. Very well. So equivalent revised pay of serial 12 is 59,980. And this is what is given to this employee. So why there is a variance? And if our
This is on 1/4/2016, my lord.
yes, same category employee.
Look, may I have a look?
No. You find out from your record. This is why we are trying to tell you
I understand.
that somebody you are adopting one procedure to make the calculation, for others you are making another procedure.
That should not be,
We are not saying this is right or that is right.
that should not be,
And if you're following two procedure
that should not.
across the board, the higher benefit should be given to all.
Two procedures cannot be.
Cannot,
made.
this is
Cannot
what,
be.
from the facts and figures we have pointed
I
out.
understand.
Please look into.
I'll definitely look into it. I'll definitely look.
Only difference is where you put the PSP. Whether you add it to the basic for the purpose of fitment, or you make the fitment without the PSP and then later on add it to the revised pay. These are the two methods.
Second one has been adopted.
In respect of some, one is made of in respect of others, something else is there.
That is wrong. If two procedures and since your lordship has said like this, then that is not correct.
This is why we are trying to tell you
understand.
from the very beginning.
That's why I'm
Your maybe you will be in contempt for making the. In the very beginning, I said verify from your employees what they are doing.
I'll just check up, Miller. Doctor will give me one opportunity, Miller. I'll just take up.
As you are trying to differentiate the grade pay and all, the complete is grade pay is 45,430 after revision.
Of this employee, Miller.
No, pay band, how is 45 the 430? Pay band 45,430.
45,430 dash.
Then
45.
then grade pay 13,300, PSP 1250. Total comes to 59,980.
His basic was 45,430.
5990.
Fine, Miller.
But original basic minus PSP is 23 plus PSP is 24 and 5990 is equivalent to 24, not 23. That means
Yes.
for fitment you taken note of included also the PSP.
I understand. That's the point. I got it. You will kindly give me some time. Just take up of the
Take up
other
what?
employees of the other.
Check up the records of everyone,
Yes.
not a few selected one.
No, everyone.
There may be a mistake in the few selected one.
Correct, Miller. Then all have to be correct. Not only this person, Miller, this petitioner before your lord. If that wrong has been committed,
Definitely
then all
all.
have to be corrected.
We are not saying it's a ordinary person.
No.
They are all your
Correct.
employees only.
Lordship is absolutely.
So whatever they are entitled, you should give them.
Yes, yes.
If they are not entitled, don't give them.
Yes.
And what we have said, the fitment will be minus PSP or plus PSP, that's a gray area. That's a gray area of some entitlement which cannot be decided. But the basic formula is grade pay band, grade pay plus PSP is the basic pay.
Yes.
And fitment is according to the pre-revised basic pay. So this one appears to be more right from that point of view.
Yes.
One you are showing may not be wholly right. Okay. All confusions removed.
Look, that clarification, that I'll just have to check the record of the other
Definitely.
employees. For that, any date.
Check
in
up
the
not
next-
of one employee, check up
All
of
the employees. I'll
each
check.
and every employee, you check up.
I personally check up.
Hmm.
I'll sit with them and I'll personally check up all the employees, how the petition is made, whether PSP has been added or not.
Find out
Before revision?
the pay slips of everyone sometime around May, June
2017.
2017, June 2017. Because the payslip of 2017 will include the pay of May 2017.
Yes.
So that will be after revision.
Yes.
And calculation, while in grade 2, they have added, well, to brought in the fitment, they have in fixation, revised,
They added grade pay.
they have added.
Take note of that
PSP,
submission also.
and that is there
To
in page
determine
37.
the fitment in grade 2, you have
Yes,
added PSP to the basic pay.
yes, Lordship.
But for grade 1, you have
You
made it without the
excluded
PSP.
And then later on added. The two stand cannot be, either my grade 2 is right or my grade 1 is right. Two calculation in.
If this is the calculation, you have paid excess to this man in grade 1, grade 2.
Yes, then grade 2. Calculation has to be equal.
List on Monday.
Saturday Lordship is or the working day for Honorable High Court.
We all are aware.
So Saturday this matter can be.
List on Monday.
Tuesday.
Tuesday. Make it Monday.
Matlab,
Tuesday, another bigger matter is fixed, I think. Unnecessarily.
Or Thursday, my lord. It will be a hearing day, my lord.
No. Why not Monday?
I'll need some time, my lord, to go through all the employees.
Okay,
That is the
Tuesday.
predicament. If that point is clarified, my lord, then not much time will be taken.
That's what we are trying to tell you, but you are not ready to listen.
I'm sorry, my lord.
We give you the indication that you are saying, repeating day in, day out only what you want to say. But you are not willing to go beyond that.
This instance, I was not.
I've been telling you, when court makes a statement, it's basis of something.
I beg apology.
We don't make a statement out of nothing.
I understand. I beg apology.
Don't give. Okay, then.
Tuesday.
I know. But again, what she is saying is also relevant. For this same man, for the revision in grade 2, you have added PSP to the basic pay and then made the fitment. But after promotion to grade 1, it is minus the PSP. And for others, in grade 1 also, it is inclusive of PSP. Follow one procedure.
That could not be. I'm very clearly saying, look, that cannot be. Two criteria for same.
That I was arguing since. I was.
I'm fortunate my friend is showing that true trust, my lord. If there some error, that will be corrected. It's beneficial for all.
Definitely.
The morale also will be boosted if they get good pay.
And how much of difference? Few hundred of rupees.
Look,
If you can
amount
make
should
your
not be a factor.
employees happy with a few hundred rupees, why don't you give them? Extract some more work out of them in lieu of it.
Yes.
Yes.
Highly approved. Tuesday.
Yes, what do you say? You have been, আপুনি তো গোটেইখিনি শুনিলে কি কয়? হিচাপ কৰা এটা পদ্ধতি হ'বনে নাই? এজনৰ বেলেগটো হ'ব নোৱাৰে। আৰু আপোনাৰ যদি কিবা ক'ব আছে ইয়াতে ক'ব নালাগে আৰু কাৰণ যেহেতু হাইকোৰ্টে এজনৰ এটা পদ্ধতি ব্যৱহাৰ কৰিছে আনজনক বেলেগ এটা আমি ক'ব খুজিছো যে এটা কৰক। আৰু আপোনালোকৰ যদি কিবা ক'ব আছে হাইকোৰ্টৰ লগত বেলেগে কৰেছপন্ড কৰিব সেইটো তাৰ। No, you don't, not required also. We thought that he won't be able to explain. That's why you require the government. As the issue is now, it's almost clear now. And if the finance department has any issues with the High Court, you take up at your departmental level. It cannot be. And whichever formula is adopted, law says, presumes that the higher benefit should be adopted. till by following the due procedure, you take some other decision.
Keep living. Monday.
Item 7 and 8.
Sir, I am for the petitioner. There are two petitions. In the second petition, a private respondent counsel.
কাৰণ মই এইটো বুজিবৰ কাৰণেহে মাতিছিলো। R. Muzumdar appears. It's always adjourned for time being. Mr. Patwari is present, Muzumdar is not present. Again, when you call next time, Mr. Muzumdar will be present, Mr. Patwari will be absent. And this went for the last 1 or 2 dates. What to do?
Everybody has to be present.
You vouch for everybody present. Then we adjourn it today. Adjourn.
Because without hearing them, your lordship passes an order.
Definitely. But why both of you can't remain present at the same time when you call the matter?
I apologize, my lord, that day I wasn't there. I came running, but
Running will not help unless you are present. What do you do? Adjourn. Adjourn on the absence of Mr. R. Muzumdar and counsel for the respondent.
Item 10 for orders.
Here, my lord, there is.
Something you said. No?
Yes. I want to withdraw this petition.
Withdraw.
Yes.
Okay. Mr. K.K. Phukon, land counsel for the petitioner, has made a statement that the petitioner, that there is instruction of the petitioner not to proceed this revision petition in the present form. In view of such statement, CRB IO 2-325-2017 is closed. Liberty granted to approach again, if so advised.
Item 11.
I took the responsibility regarding petition notice on respondent number 2. In the condonation petition, it was my paper application. And he was my, he has executed shell deed in my favor.
Respondent number 1 to disclose the whereabouts of present location of respondent 2.
I am searching, some time is required. Because
Okay.
in 2008, he has executed.
They are related, 1 and 2.
No. He was my attorney, he has executed a shell deed in my favor.
He was the,
He is the executant of the shell deed as the attorney of my vendor.
as the attorney of the vendor, respondent number 2 had executed the sale deed.
In 2008.
And you are the vendor.
No, I am the purchaser.
Purchaser. You were purchased from the power of attorney holder. And,
Through power of attorney.
and Mr. Sharma, you represent?
I am not the appellant, sir. I am
I know appellant. Who is the appellant?
Appellant, according to Lordship appellant, they have filed a suit claiming that they have purchased land some other vendor. I have purchased some other vendor. They have filed a suit that my sale deed should be cancelled on the ground that my vendor has earlier sold the land to other person. They have not made that person.
To another person in respect of your land or somebody else's land?
My vendor's land has been sold earlier to some other person. According to them,
Your vendor had sold his land,
to other person,
before selling it to the
before
respondent.
selling to me. According to them, they have not made.
No, if he had sold to some other person, cause of action will lie on the other person to challenge it.
He has challenged.
Who is this
He
man?
has challenged my sale deed on the ground that my vendor.
Now,
has
what
no
is the
land.
locus?
That is why Lordship.
So far as Scrutiny is concerned, it was my lord, I.
Mr. Sharma, if I've understood Mr. Goswami rightly, he had purchased from the power of attorney holder of a vendor a particular plot of land. Okay. Your allegation is this land was sold by the same vendor to some other person earlier. This is what Mr. Goswami says. I don't know, maybe right, maybe wrong. We have not gone into the question. If this land was sold by the same vendor to another person, The other person may have a claim against Mr. Goswami's client that I am prior in time, I have a right title and interest over this land. It cannot be yours. In this circumstance, who is this appellant before us?
What happened?
Not happened. Who is this appellant?
This particular plot of land was purchased by me. He
No,
said-
are you the other person?
Yes. He said this particular plot of land is purchased by him. I am saying that I purchased this plot of.
Then who is the other person then?
Before Lordship, allow me to say something.
No, you don't have to use the expression allow.
Umesh
Mr.
Das-
Sharma,
Madam,
as long you were clear in what you are saying, we allow you everything.
I am purchasing this plot of land.
You
He
have
claims he
purchased. So therefore, we are asking you a very pertinent question. Please listen and answer and don't use these expressions allow and all. Mr. Goswami says his plot of land is alleged to have been purchased by another person. You are saying this plot of land was purchased by the appellant. We want to know whether the another person referred by Mr. Goswami and the appellant, they are the same person or they are again different person.
The present respondent is possessing my land, which I have purchased from the rightful owner.
From the
Rightful owner. What happened? He is
Just-
claiming
just a
my
minute.
land as his land.
And
I am claiming this
just a
plot of
minute.
land is my
Is
land.
the rightful owner your rightful owner and his vendor same person?
No, different.
Different person. So now we will decide who had right title and interest.
Yes, ma'am.
Over whether your vendor had the right title and interest or his vendor had the right title of interest. We'll decide that. Now, why is the second appeal?
Second, if it is for my right, I have claimed for right to interest and recovery of body.
First, show us
Ma'am.
by which instrument you had purchased the land.
Yes.
Let us look into it. Page number
Plaintiff is that is 39.
39.
39. Is that plaintiff?
39 is title suit.
Plaintiff.
You are a plaintiff.
I am the plaintiff.
Umesh Chandra Das was the original patadar of two
Vigilance.
bighas, dag number 35. Patta number 45. Of village, how to see. Who are you are? Dinesh Chandra Sharma.
I am the
Yes, Umesh Das sold two kotha to Dharmeshwar Sharma. Umesh Das sold two kothas to
Then
Konaklata Devi and Khogen Pathak. Umesh sold to Himeshwari Borua. Thus sold his entire land under his possession to the above fund. Correct to state that the above named Dharmeshwar Sharma and Konaklata Devi. Konaklata Devi. Okay. Sold their portion of land to two persons, Soripul and Kholilur. These two persons got their name mutated in revenue record. Thereafter, Khogen Pathak are to be sold even to plaintiff. So you purchased from Khogen Pathak. Utpal Sharma. Who is Utpal Sharma?
Utpal Sharma purchased.
We are not
Vimal-
concerned with Utpal Sharma.
I am not.
What we are concerned is Khogen Pathak.
And Utpal Sharma is also not there because from
No,
Vigilance,
no.
plaintiff number 3 purchased from Utpal Sharma.
This one will follow good.
Then why have you, this is a dismissal for non-gender of causes of action.
And also for position part is concerned. I am
No,
posing,
in that case, plaintiff
I have-
3 should have filed a separate suit.
no, I have no claim against my Storiful Hawk or Khalilur Rahman because
You cannot have. They have purchased their own land.
they have purchased their
Huh.
own land. They are posting their respective plot of land. But so far my plot of land is concerned, again, my vendor purchased the land prior to Dharmeshwar. Dharmeshwar Sharma is the vendor of the respondent number.
You have purchased from Dharmeshwar.
Mr. Sharma and Kanokata Devi.
Dharmeshwar Sharma solely through.
Just a
restaurant
minute,
number
we have
2, my-
purchased from
Dharmeshwar
Dharmeshwar
Sharma
Sharma and Kanaklata Devi.
Through restaurant number.
Just a minute. Plaintiff state that the Dharmeshwar has sold their portion to Soriful. Are you Soriful?
No, no, no.
According to them,
Yes.
Soriful, he sold the land to Soriful. That is why Dharmeshwar Sharma and Kanokata Devi has no land. That is why my sale should be cancelled. According to him.
Yes.
What is Lucas?
So far, my Lucas is concerned because I have purchased my land. Sorry, is not. Sorry,
Mr. Sharma, we are having little difficulty.
Sorry,
Mr.
coming
Sharma.
to my land.
Mr. Sharma,
Fine.
I know you argue very well. And you
Good,
like to
I'm-
continue
I'm
with your
very-
argument. That also I know. You also like the court to hear you. That also I know. But please answer.
Fine.
You have purchased from Khogen Pathak.
Fine.
This is your stated case. Khogen Pathak had purchased a separate plot of land from Umesh Chandra Das.
Fine.
He had purchased from Dharmeshwar Sharma and Kanaklata.
Fine.
Kanaklata and Dharmeshwar also purchased another plot of land from Umesh Chandra Das.
Fine.
So why you are agree with his sale deed?
Because
You enjoy your own land.
what Hogan Pathak has purchased from the vendor original. He sold that particular plot of land to me.
Yes, you enjoy your land. No
I-
one is stopping
yes.
you.
I took possession over the said plot of land.
Huh.
Subsequently, I disposed from that plot.
By
And
whom?
So for my lord, our claim was
By
such,
whom?
my lord, this my lord, number one and-
So
response number 1 and 2.
where is the schedule of the land
My lord,
you
page,
had
my lord,
purchased and disposed?
page 39 is the
Page
schedule of the line.
39.
46,
No, there is only one schedule.
39G, my lord.
There is only one schedule.
Yes, my lord.
Plot of land measuring 3 kothas.
3 quotas, 9
Okay.
less.
Huh? And you had purchased from
I have purchased from my lord Hogan Pathak.
Khogen
Khogen.
Pathak. Just a minute. Khogen Pathak had sold you 2 kothas.
My lord,
Very well.
my lord.
Then in the schedule land, how your land becomes 3 kothas then?
Because originally plaintiff was 3, my lord. Plaintiff number 3 and plaintiff number 1 and 2's land is contiguous land. And they have filed us to join.
That's why you intend to dismiss your suit
My
for misjoinder of causes of action. Because
we have our case, I stated in. our
no,
right.
there in a civil dispute of land, it is not our case. It is always my case.
That's-
When you converted your my case to our case, we can never determine that our right.
Because
There is no,
here in this case, my lord,
see, if you had conjointly purchased a plot of land through one sale deed, we understand it's a
Yes,
a
yes.
common land.
Yes.
But when 2 persons have purchased 2 different plots of land through 2 different sale deeds, it can never be a case of our land. It is be a case of my land and his land.
my lord, so far their grievance and relief has been, my lord, similar. They have joined together.
You cannot
They have.
find out the CPC.
Yes.
We are dismissing. I don't know what you
My
do.
lord, so far, my lord,
Find out the CPC.
if you lordship is, my lord, here this matter, I have not actually prepared for hearing. Lordship may take.
Then why are you
another
before
day
the
for-
court?
and
If you are not prepared, why are you before the court then?
Before my lord, because it was fixed for order, I am still on.
There's nothing
impression-
called order hearing.
I am on such impression that response number 2 will appear or.
No, it's a matter of 2012. There's nothing called order, disorder and all.
uh,
We impose a cost for not being prepared. Pay cost of
then
2000
I
and
I will pay my lord. together.
pay.
From my pocket, my lord, I will pay. Because my lord,
I
without
don't know
preparation,
what
I
you
cannot
do.
give, my lord, injustice to my client.
Don't give us all those sentiments from your pocket or his
Yes,
pocket.
no, whatever, my lord, I cannot give my injustice to my.
So
lord.
now
I have to prepare my. lord.
I
Any day,
think
but
this
any
is,
day,
appears to be a
access
case of misjoinder of causes of action. Find out the which
Besides this, the Vishnu Prasad Deka was joined as a plaintiff. He never come before the court to educe evidence. Vishnu Prasad Deka was a
find
plaintiff.
out the wakalatnama whether he signed or not.
He has not appeared.
No, did he sign the wakalatnama?
I do not know. He
Please
has
check
not
up.
appeared. No evidence.
No, check up the wakalatnama.
Lower court has.
ৰেকৰ্ডটো ক'ত আছে
Healthcare.
এইটো নহয় LCR তলত নাই নেকি
Healthcare has called for, but that was adopted.
LCR not received for 10 years for 11 years LCR not received why
It is of
I never
2022. It is appeal of 2020.
12 নহয় নেকি
22 actually.
oh 22 man then it's okay you take time no but cover it is written 12
It was
in the cover it is written RSA 25 or 2012 that's okay you want time agent of the prayer of Mr. Chairman when do you want
so far, issuance of notice of the respondent number 2, that may be matter.
Achha, that is also not complete
Okay,
is not-
complete. But sir, earlier occasion, okay, there is a delay for condonation. And delay, they have made a paper publication. But in the appeal, I have myself taken the consent that I will charge the person Vijay Sharma because he was my vendor. I will try to contact him to appear before the court. That is why court has directed me to.
okay so what order should I pass now
Some time it will. Okay, I'm searching. Okay, these are eight.
agent of the prayer Mr. S.K. Goswami
20
length
years
of
back,
respondent number 1 to find about the whereabouts of respondent number 2 and thereafter take steps thereafter enable the appellant to take steps
Public.
Matter apparent to take by registered post or matter. After.
first you should know his whereabouts then
Right,
you only
yeah,
take
that's
steps
right.
otherwise
That's
in
it.
which address will you take steps
Yes, yes.
Public. Public.
And so far, reminder be.
এইটো ভালকে লিখিব ক'বচোন দেখাতো দেখা 2012 দেখি the cover shows it is of 2012 and 2012 matters we are taking it from a different perspective
2022. Public. Public.
Item 12,
review petition for review
This matter was all along being heard by Justice S.K. Mehdi. There is no harm of this, your lordship can also take up, because just order passed by,
no is there any it's a review against the order by Justice Methi
no, it is by Justice Honorable Professor.
then I think it will go by roster bench arbitration or roster আছে নেকি আবার
Right.
say if it is there it will be for this one because Methi just say Methi won't be able to take up
It's all along being listed.
because
Petitions of the year 2016 to 2020.
2016 to
2020.
Originally,
এটা তো arbitration petition of 2014
originally of 2014.
14 or কোনে লয় Justice Methi took it up because it was a roster of that court on those days
14 police cases.
then you argue yes
Lordship, Lordship, here is this case, Lordship. One arbitrator was appointed Justice late. Honorable
anybody
Raj-
appearing for the respondent in the review
Respondent is appearing for VC, Lordship, in person, Lordship.
Lordship, I'm here, Lordship.
you are here are you ready with the hearing today
I'm ready, Lordship. I'm ready.
okay
Lordship. Lordship, here is
for
this-
appointment of arbitrator
For arbitrator was appointed, this proceeded, but before he could complete, he expired. Lordship, thereafter, they filed a substitution petition, and the secretary of the tribunal was appointed as a, but so far as the present.
no
petitioners-
let us see the appointment of the arbitrator which order requires to be reviewed
Lordship,
take us to that
page 10.
page 10 page number 10 heard Mr. Kansham Diwan applicant also heard Mr. Gupta. This is IS civil.
Yes.
IS civil for?
Uh,
IS civil in which case?
in original arbitration petition, Lord.
In arbitration petition, this IS civil.
ISCP.
What happened to the arbitration petition?
The arbitrator was appointed, but before he could complete the proceeding, he expired.
He
Thereafter,
died.
they filed this IS civil for
Prayer
substitution,
file seeking appointment new arbitrator.
new arbitrator. And
Earlier arbitrator Colonel Manoranjan Goswami passed away. Chakraborty submitted is no objection in Momita Bora, advocate come life individual member of Indian Council. Appointed
admittedly,
arbitrator
Lordship,
is
at
all.
that time, Lordship, this petition was disposed of. There was no objection, neither consent from us. Because this petitioner did not receive any notice or any intimation from us. I was not able to contact. But why we seek that?
No, Mr. Chakraborty Lalsiji submitted that no objection, new arbitrator is filed.
It was written, Lordship, but there was no consent also because I didn't have any communication.
No, there is a
from the-
difference between no objection and no consent. Court writes no objection.
That's true. It is-
Your silence is also no
The
objection.
reason which is necessitated, Lordship, this lady, well, Lordship, this Miss Mamita Bora, she was appearing against us in 3 of the cases, Lordship,
In this particular matter.
in this very different case, Lordship.
Okay, you have all.
Moreover, Lordship,
And why was Madam Bora appointed?
the petitioner suggested.
Yes,
Lordship,
Mr. Dhiman.
Ghanshyam. Lordship, Lordship,
You can change the arbitrator if you want. You
Lordship,
suggest some other name to the agreement of the respondent, we'll appoint that in place of Madam Bora.
Lordship, I'm not agree with the petitioner because what happened, Lordship, the arbitrator.
Mr. Dhiman, kindly increase your volume, please.
Oh,
It is not very clear.
You're not very audible, Mr. Dhiman.
Last few occasion he
Now
appeared.
it is clear, Lordship. No.
Maybe he's having difficulty. Let him take the video. We have no difficulty with that. But at least
Now
we
it is
should-
clear, Lordship.
No, can you increase the volume of your apparatus you were using?
I have increased, Lordship. There may be some other problem
Ate
actually.
pari nahi.
I mean,
No, I can hear you, but it's so faint. It's difficult to understand what you
So,
are saying.
Lordship, then I fix a date in the next month. I'll come and appear in person in the court, honorable court.
Seeking next date, he will appear in person.
You're appearing person, yes, very well.
Yes.
But which date you want?
In the last week of December, Lordship.
Last week of December.
Second or third, because we have a holiday in last week.
Then in January first week, Lordship. January first week.
Okay with you. Mr. Ghanshyam Das Dhiman, the applicant, the respondent in person, prays for an adjournment for the matter to be listed on. So and so. You take a fixed date, we'll list on so and so.
Obliged, sir. Obliged, sir.
8 January.
Obliged.
Obliged, Lordship.
After.
ভলিউমটো ইমান কম কিয় হৈছে?
তেওঁৰ চিষ্টেমটো কিবা এটা।
তেওঁ তাতে কিবা কাৰণ এনেটো ইমান কম নহয়।
Item 14.
14, yes, item 14.
May I please, but before going to submit by my learned friend, I want to submit that I have the instruction to that I am appearing on behalf of defendant. Defendants are going to appear in some other country, engage some other set of country.
Not you.
Not you. So sometime maybe.
You are H.J. Tamuli.
H.J. Tamuli.
Adjourned on the prayer, Mr. H.J. Tamuli, non-counsel for respondent.
Obliged, my lord.
But
Item-
your clients don't like you.
Maybe
They want to engage somebody else.
some other, engage some other.
Why? We find you, Mr. Tamuli, very competent.
He has been conducting even in revenue board also.
Sorry.
In revenue board also, in revenue appeal.
No, Mr.
he-
Tamuli
he
is
has
quite
been
competent.
conducting.
Can you?
It is
It's
parties wish, my lord.
Between you and your client.
My lord,
Adjournment. Okay.
my lord. Obliged.
Thank you.
Item 15 for hearing.
Where we go watching.
15, yes, Mr. Chaudhary.
This pilot, suit was.
I think I heard it once, no?
Yes, yes.
Appellant claims the right title over the suit land basis of mutation order in respect of his predecessor. Revenue record is available, mutation orders.
Yes, mutation orders means, my lord, the Jawabandi copies are available. I have a flag mark, my lord, some of them.
Jamabandi is available.
Jawabandi is available.
So your submission is
My name came earlier.
mutation of 1962.
Yes, even prior
And
to
Mr. Goswami's submission, mutation of 1964
that, 64.
in respect of the same land.
Yes, yes.
How the mutation changed? Is there anything in the Jamabandi?
No, nothing.
By which order it was changed?
No, my lord, their name has been reflected, my lord. Only some noting is there.
Madam Bormon, this may be a case for you to look into. If I understood rightly, Mr. Chaudhary says he relies on a mutation of 1962, saying that his predecessor interest name is there. Mr. Goswami relies on 1964 mutation. They have verified and same that this is pertaining to the same land. Then how did the mutation change from 62 to 64 that his predecessor goes and Mr. Goswami's predecessor comes in? I think the government will have to explain that. Somehow it took years, it was.
Document, document.
No, I want only the mutation orders, not so many.
Yes, sir.
Mutation
This is Jawabandi copy, some noting.
এই নতুন কি এটা হরিজন্টাল মার্কিং করি অল মিউটেশন জমাবন্দী কপি এটা দিয়কচোন সাইটৰ ফ্ল্যাগ মার্ক কৰি দিব দিয়ক
May I submit one thing? So, this case, the applicant has filed title suit claiming right title in entire. That suit was decreed and the state title suit, we have also filed counterclaim
counterclaim
regarding position.
and suit decreed counterclaim
But both the counterclaims were rejected.
counterclaim rejected suit is decreed
Against that, appeal has been filed. In the appeal,
who filed appeal
we have filed.
you have filed one against the dismissal of the allowed the suit and another for dismissal of the counterclaim appeal then appeal what happened
In appeal, my lord, the decree was reversed.
decree the suit was reversed
In favor of the plaintiff was reversed, and as well as the counterclaim
allowed
the parties not allowed.
counterclaim remains dismissed
Yes.
suit which was decreed in favor of plaintiff now stands decreed in favor of defendants
No, ma'am.
reversed so suit also dismissed
Yes.
suit also dismissed counterclaim also dismissed
Against that, they have filed this appeal, ma'am. Claiming
so
right
both of you can hand over the plot of land to the government if his claim is also dismissed your claim also dismissed I think Madam Bormon will be entitled to that land
My lord, simple point is that just because he has filed his suit on the basis of title, so he has to prove his title on whose basis.
no I understand what you're saying there is one judgment somewhere I have read that in respect of the old titles, the Jamabandi and the mutation orders are also good indication of title. Normally, mutation orders and Jamabandi is no, because it is only an indication of that you may have a title. Number one. But if it is a very, very old entry, there is a presumption of it being correct. And this also gives a kind of a title because old entries now are very difficult to verify on what basis those entries were made. Suppose it is a 80-year-old entry. How can you verify it based on which sale deed, where is the sale deed? 80 years means the third generation must be litigating. What happened to the sale deed, no one knows. So there is one judgment. Often I can't tell you.
My lord, in this case,
Further point is that.
So once he says that I am relying on a Jamabandi to show the mutation,
Only Jamabandi, Pata is not there. Pata is in my favor, my lord.
Patta is of 1984.
Yes. That has been exhibited.
Where is the Patta?
Pata has been.
Show us the Jamabandi and the Patta both.
Yes. Pata is Pata.
Understand. So we'll try to balance between the two. Whether the Patta will, if the Patta is in your favor, then you should have filed an appeal against dismissal of your counterclaim.
It could have been matter.
Otherwise, we cannot reverse that without an appeal.
Yes.
We can only either dismiss his appeal or allow his appeal.
I have not filed any counter appeal.
I think you should have filed. Do you want to file?
No, my lord. That is because, my lord, I could not contact my client because it is an old one.
RS of 2009, very old.
I tried several times, but I could not.
Now, who is occupying this land?
That is also not.
Huh?
That is also not known, my lord.
Mr. Goswami doesn't know who is occupying.
Because I filed suit for recovery, my lord. So it is not in my possession.
Let us see the that Jamabandi
Yes.
and also the Patta. Like about the Patta also. Patta he is relying on. Mr. Goswami, please find out the Patta also. Okay.
Yes, I marked.
Yeah, marked it. Itu Jamabandi niki. Who is your predecessor in interest?
Yes, that is my lord. Soyez Ali Fakir.
Soyed Ali?
Okay.
Soyed Ali Fakir, Peter Bodo Fakir or something, no?
Yes.
Bod Fakir. Bod Fakir. And in his name, whose name comes in? In place of Soyed Ali Fakir, whose name is entered? Because Soyed Ali is struck off.
Jawabandi also, Soyez Ali Fakir's name is there in 1962.
No, this is 62. 60. No, this is 62.
Yes, from 1952, Soyez Ali Fakir has three parts of land, my lord. Ultimately, it has come to 17 bigger. 6 bigger than 12 bigger. Right there. Montagu has not been properly written, my lord. That is why it has passed. It's very difficult to.
That's no, Montagu should actually be in detail.
Yes,
Then it's very easy for everybody to understand.
Nowadays, it's written in detail.
Yes. By so and so mutation,
Yes,
all
yes,
the
yes,
details
yes,
so and so passed by so and so. This land
Yes.
is mutated in favor of so and so, in place of so and so. Here, nothing is there. Sri Mrito to ki ka hakimor iman tarikhor hukum mote iman 165 dagor tam matir ভূমিজৰ ঠাইত ক্ষেত্ৰীয় শহৰ নামে নামজাৰি কৰা হ'ল ক্ষেত্ৰীয় ক্ষেত্ৰীয় শহৰ নেম অফ পাৰ্চন ক্ষেত্ৰীয় শহৰ ইমান হকিমৰ মতে Oh, no, no, ক্ষেত্ৰীয় শহৰ is not there, মানে ক্ষেত্ৰীয় শহৰ নামে ক্ষেত্ৰীয় শহৰ মানে কি নহয় ইয়াতে প্ৰথমটো ভূমিৰ স্থলত ক্ষেত্ৰীয় শহৰ নামে নামজাৰি কৰা হয়। নেক্সট ওৱান ইজ অমুক অমুক হুকুম মতে ক্ষেত্ৰীয় শহৰৰ স্থলত সৈয়দ আলীৰ নাম নামজাৰি কৰা হয়। This is in 1941. First one, no, is 1942. First one is 1941. ক্ষেত্ৰীয় শহৰ. ক্ষেত্ৰীয় শহৰ must be having a man. Some person, I think. ক্ষেত্ৰীয় শহৰ কি নাম? সৈয়দ আলীৰ নাম নামজাৰি কৰা হয়।
There is practice since 1948. Part by part. And there, my lord, the investor,
Anyway, who is your predecessor in interest?
yes. So is there, okay.
Soed Ali.
Yes,
So Soed Ali Fakirer নামজারি করা হয়। We don't have to go anything beyond that.
I'm
নামজারি করা হয় Soed Ali. He is your predecessor in interest.
Yes, I am his there.
And this is a Jamabandi of which year? Anyway, let's say order of 1942.
Yes.
Very well. Now, identity of the land.
Tag number, patta number is there. On the left hand side. So, column.
165 dagor something. 165 dagor. Yeah, it's there. Somebody, some Bhumis, from Bhumis it came to Kshatriya Hor. From Kshatriya Hor it came to Soed Ali Fakir.
Yes.
Now, did you get your land mutated in place of Soed Ali Fakir?
Yes, it is there, my lord, but that I, in the exhibited document, I have not found it. But one of the German, the copy, my lord, it is there, my lord. So that-
You were mutated.
Yes, yes.
So, this is land of Dag number 165.
That is Purani Dag number, my lord,
165.
this is Purani 119 and new 58 is the patta number. And
No, Dagor. 165 Dagor.
Yes.
That number is defined.
So suppose, Mr. Chaudhary, I accept that you have prima facie led something that you are right title interest over Dag number 165. Now, what is the Dag number of the suit land?
Yes. It is there in the plate, my lord. Whatever is the plate, I have to accept this, my lord. The patta number 111 old and 58 new, and Dag number 833 and 355 was original.
So it is not of Dag number 165. Your right title and interest
Yes.
through your predecessor Soed Ali in respect of Patta number 165, Dag number 165. But the disputed land is not Dag number 165. Old, new, everything is different.
That part is there, but
Uh,
important part.
So you have established title over that land and you are claiming the suit over another land.
Yes, but it is this balance, it is very important point. That number keeps on changing, I have to see my lord again. my
Then you
lord.
find out the hierarchy of the Dag numbers. Say in 1945 it was Dag number 165. 1970 it became so and so.
Yes.
1990 it became so and so. Find out the hierarchy. It will be available in the revenue record. Mr. A. Chaudhary, Lanka petitioner seeks for adjournment to provide the hierarchy of the Dag number 165, which is referred in the order dated 7/11/1941 in the Jamabandi. What Jamabandi? In the Jamabandi of village Ek number Kuadonga.
Yes. Kuadanga, under Moja Nabuj.
Okay, fine.
Yes.
Find out.
Yes, that is the issue.
The aforesaid information is deemed necessary to trace out whether doc number 165 referred in the order of the referred in the order mentioned in the Jamabandi dated 7/11/1941 can be traced to the doc number of the suit land involved in the present AP. 5 minutes. Respond next week.
Yes,
This next week.
my lord, just for a moment.
And where is the patta now? Let us read the
That
patta.
is what, that, the second one.
এক number Khwadonga. The village is okay. Take up the patta, whether
Yes,
it,
yes, I'll,
please look into, study the patta,
yes, yes.
whether it pertains to this land or pertains to some other land. If it pertains to this land, then you will have to explain why patta was issued. You cannot issue unless it's a government land. Unless government land, revenue department cannot issue a patta if it is already a patta land. Can't you settle it amongst yourself? How can you go trace back to the history of now almost nearing 100 years? So I am now almost 90 years now to trace out.
They are not cooperating.
Who is not cooperating?
Party, the phone number also.
Okay, your client is not cooperating.
Their phone number, they given, I'm trying to contact them, they are not.
Do one thing, remain absent for 2 days, we'll dismiss on non-prosecution.
Yes, I requested my friend also.
I am also trying to.
No, once we dismiss
Yes, then they would.
and he'll go for its execution or something, he'll come back to the court. What else to do otherwise? It is a very, very old claims. If you can settle amongst yourself, it is always better.
Yes.
Maybe some misunderstanding, something somewhere with someone. Or one of you,
In all probability, my lord.
no, Mr. Or another possibility, one of your clients, either your client or his client, is a little more greedy and wants some more land. Otherwise, they must be residing as neighbors.
Not getting no response from any other side, my lord. I'm thinking that they have already decided amongst themselves, probably, my lord.
One point, my lord.
That is an old principle. When clients don't respond to the lawyers, they must have settled out
Yes.
their issue. And they feel that the lawyer is calling me to hand over some fees. So better avoid it. Both are not responding. They are happy with each other. And none of them want to contact either of you two.
That number 150.
Okay, when do you want?
Yes.
After a week.
Yes.
List after a week.
Item 19.
Obliged.
Oh.
Now you decide.
Yes.
This client, you have contact.
Yes.
Yes.
Time.
Huh?
Time.
Time. You want time?
Oh, 15 minutes time is there.
Hmm?
15 minutes time is there. It is possible.
It is 4 o'clock nowadays or 4:15.
4:15.
4:15. Or you want to go? If you want to go, I don't mind. 19 minutes.
Election minor. Service matter minor.
Oh, service
Yes, that-
matter.
Actually, what happened? Advertisement has been issued.
এই হেৰি তো কোনদিনা আছে এই যে আৰ্কিটেক্ট যে কৈছিলো ইন্টাৰপ্ৰেটিং হেৰি চিভিল কোড জুৰিসডিকশন পৰহি যে কৈছিলো একেদিনে দি থৈ দিয়ক Who was the plaintiff? You are the
I am
plaintiff.
Actually,
Of course, now we can't, but I want to hear on one aspect. In another matter, I had requested Mr. R.K.D. Chaudhary also to address the issue. What is the jurisdiction of a civil court? Section 9 CPC?
yes,
Hmm. I think to avoid this kind of situations, an interpretation of Section 9 is required. Court shall, subject to the provision, have jurisdiction to try all suits of a civil nature. First, you submit what is a suit of a civil nature, dispute of a civil nature. What is included in a suit of a civil nature and what is not included. Accepting suits of which cognizance are either expressly or impliedly barred. Which are the subject matters which are impliedly barred? Expressly, of course, there are some municipal act,
Yes.
something done by the municipalities, but
expressly
and
barred.
various. What is impliedly barred? No court has gone into this question till now, I'm telling you.
one thing, my lord, I think in the Assam Secondary Education 1977, the Act, rules have been amended, my lord. In the Act, my lord, there is the provision, my lord, regarding suit, my lord. I'll read, my lord, your lordship, my lord.
Assam?
Assam Secondary Education Provision Act 1977. Act remains the same, actually. Well, suit and proceeding, rule 6, my lord. No suit, prosecution or any other legal proceeding shall lie for anything in good faith done under this act, except with the previous sanction of the government. Except with the previous sanction of the government.
So here there is no sanction.
Here there is no.
This may be one aspect. This must be an express bar. But I also got into what is implied bar. Because CPC speaks of, firstly, it must be of civil nature. We have to find out the broad parameters of what is a civil nature and what is not a civil nature. Then again, what is an implied bar? Otherwise, we are having some very disturbing matters. One matter I told you, somebody filed a suit for promotion. After his retirement, one second appeal came. And after some time, he says the man died, become infructuous. So a man who claimed promotion about 30 years back, as because it was a suit, injunction here, injunction there, MFA, this, that, first appeal, second appeal, the man died. Whereas if you are claiming promotion, you can straight away go to Assam Administrative Tribunal or you can file a writ petition. At least within a few years, you will get a determination. So are these kind of litigations not impliedly barred? It's very easy for a district lawyer because normally especially in the Barak Valley side, I have noticed, because Guwahati is deemed to be a little far off. They'll go to a lawyer there, okay, don't worry, I'll file a suit and get an injunction.
Yes. There are a number of.
And the man is happy. But he doesn't realize what lies in his future. After some days, there will be an application for recall of the injunction. Then there will be miscase, misappeal, this, that, it will go on and on for a few years. After the injunction is settled, then the suit will start. Then the first appeal will come, then the second appeal will come. So it's almost like litigations in 6 different layers. 3 layers on injunction, 3 layers on the main suit. And ultimately, the fate of that man. The appeal need not be decided because he died. So, if we can put in some kind of a requirement of the civil courts to also go into the question of section 9 before taking cognizance of a claim, because because 9 also talks of cognizance. Well, cognizance is impliedly or impliedly barred. So don't take cognizance. Return the plain. That order, I think, order 1, rule 10 or something is there. Hmm. Return the very kuntu asil. Return of plaint. Not 10.
Return of order 7, rule 10.
Order 7, rule 10. Return of plaint is not conditional in any manner.
Yes. 10 is return to
Another matter, why I want to list it on the same, hit I can video. It will not, it mati. It mati matter, cover mati, government pukuri khandi.
This matter come earlier.
This one. Yeah.
This matter come
In
earlier.
another matter, there is a suit in somebody's land, the government came and dug one pond.
Oh, yes. Yes.
Something like that. So if the government is coming and digging somebody's land, it's an illegality in the administrative law. Highly read, get a stay. If the state takes a stand, no, this is not your land, this is our land, then it is a question of disputed question. That event you go for a suit. But if you go for a suit at the first instance, the civil court will require to prove your title first.
Yes.
So that's the first hurdle. On one hand, you want that the government should not come and dig your private land and make a pond there. To get protection, first you'll have to prove your title now. Is this not a more circuitous method? Why don't you file a writ petition straight away? We'll issue notice, Madam Borman will get the information why we have dug it. If she takes a stand, no, this is the government land, not a private land. Very well, we'll send it back to the revenue department to determine it. Or then you go for a civil. And if it is not, it is his private land, that objection is not there. We'll ask you, why are you digging somebody else's land? Now see the fate of that man. Now we are in some, at what stage we don't know, after filing of a suit.
They should not have filed a suit.
Yes,
But-
They should not have.
But this is rampant in some of the districts.
But in Dhubri district, I found not only I got two cases in that.
So straight away suit.
Yes, straight away. So one Anganwadi worker filed suit.
So instead of the lawyer giving a proper advice to the client,
They
he'll
need to
think
file
that we
it.
retain the client, file a suit.
Yeah.
And every month, every date, I'll keep getting my.
In fact, there is suit pending for pension matter in High Court, in Silchar matter. The party came to me.
Hmm.
Yes. right.
So are the lawyer not doing a disservice to that litigant?
Exactly.
Pension matters, had it come here, we'd have used a
Yes, yes.
little stricter words against Madam Borman. and try to get the matter settled almost immediately.
Before lordship, it may be, now it not a stage, but it may be converted to writ petition. It just be disposed of the matter on first day.
Can we convert a civil
That
jurisdiction
is
to
the-
226?
this is the problem.
We'll have to check
Yes.
up. I don't think so.
This is the
But maybe yes also.
many years.
A High Court has 226 jurisdiction. If you notice something, possibly there may not be a bar to convert it also.
Yeah.
Then the suit will go.
Yeah, it will go.
We'll assume our jurisdiction ourselves.
Yes, yes. It will go. It can be
Article 226, so your lordship.
at the power. The lordship
There
can
is
do.
no bar. If regarding conversion, we have to.
Then
So both the matters that pond digging, only question is, why are you digging? If you can justify that the government can come and dig, it is okay. If you cannot, you have to stop. Or else you acquire that land and then start digging. But see the fate of that litigant in a suit now.
Here also in this case, of course, in this case, we violate our.
First thing, the defendant came and took the stand, prove your title.
Yes.
And rightly.
System. Going well.
Okay, we'll hear you. একেটা দি দিব পাৰিব। Let's wait for list on, keeping it open. We'll check up the other matter. We'll try to take up on the same day because possibly we are going into this question for a limited purpose. We are not setting aside anybody's order on suit not being maintainable, but we'll want to give some observations that it's also a duty of the civil court to look into this aspect. Before admitting a suit, it's also a duty is cast to look into it. Otherwise, you're creating more problem than a solution for all.